Tai labas rytas visiems. Labai malonu matyti tokią pilną salę.
Welcome to our conference. It is a pleasure to see so many of you in the audience. This is the second day of the conference, and this day is dedicated to child-friendly justice, and we are focusing on forensic psychiatric and psychological assessment in cases of child victims. I see many speakers and colleagues from abroad are here for the second day. It is a pleasure to see you again. Today we can also reflect on what we heard yesterday. And without further ado, I would like to give the floor to Dr. Edita Žiobienė, Ombudsperson for the Protection of the Child's Rights, to make a welcome address.
Labas rytas visiems.
Good morning, ladies and gentlemen. This day is the continuation of our conference. Yesterday, we spoke about harmful sexual behavior in children, and we focused on harmful rather than criminal. But today, we discuss other complicated and sensitive matters, which is justice system for children in the cases of violence against them. And we will discuss the justice system in the eyes of the child and the need to ensure a smooth process that is least harmful for a child. Sometimes as adults, we have a different approach on this, but children don't see our methods or our offices suitable. Therefore, we have to take child's perspective in mind. As the state, we have achieved a lot in the area of child protection and in the criminal proceedings. We have forensic psychologists. Psychologists attend and participate in child interviews, forensic interviews. And in any criminal case, a child needs a psychologist, and we have been able to ensure that. The 20th of November is the Day for the Protection of Children, and therefore our conference more or less coincides with this date. We have to remember that our key focus is children and ensuring their rights. Yesterday, we appreciated the contribution of the British Council and the Lithuanian Office of the Nordic Council of Ministers, and our foreign guests from Nordic countries, from the UK and Latvia. We actually share our knowledge in order to be able to learn from each other. Thank you.
Tai ačiū klausyt.
Thank you. Well, actually, I did not introduce myself. Edita said that we're all here because we are really concerned and we care about children's rights. I would like to introduce myself. I'm Rima Užabalytė, and I'm very interested in this topic. I have been teaching criminal procedure for 30 years, and for 10 years I have been working as the judge at the criminal division of the Supreme Court of Lithuania. Hopefully and luckily, we don't have many cases of when children are victims in our procedure, but still this topic is really important and relevant for us. I would like to give the floor to one of the hosts of today's conference, Julius Sabatauskas, chair of the Committee on Legal Affairs of the Lithuanian Parliament.
Gerbiami konferencijos dalyviai.
Ladies and gentlemen, I welcome you to this international conference. You discussed a very important topic yesterday, and today you focus on child-friendly justice and forensic, psychiatric and psychological assessment in cases of child victims. These topics are very relevant. Child-friendly justice is not only a legal term, it is our common commitment to build a safe and supporting environment for children. Today we will focus on an extremely sensitive area, the role of forensic, psychiatric and psychological assessment. Which is related not only to child victims, but also to perpetrators. But we have to focus on children, and the process and the procedure, criminal procedure in a child-friendly justice should not be traumatic for children or should not re-traumatize them. We have the law on the protection of the rights of the children, which stipulates that any activities related to children should take into account the best interests of the child, and this is in line with the United Nations Convention on the Child's Rights. The guidelines of the Council of Europe on the child's rights provides for the creation of environment which is safe for children, where children can safeguard their safe environment and their dignity. We also have the law on medical health, and it stipulates that the forensic assessment of children should be carried out in a responsible way in order to ensure that the process and the procedure would not additionally harm a child. Children victims of violence or sexual assault feel a great psychological pressure, and a criminal procedure can become a secondary trauma source. Therefore, the mental state of a child should be always considered in order to ensure the best interests of the child. Lithuania faces practical challenges such as the lack of qualified experts, lengthy procedures of child assessment. When we address the challenges, we should always bear in mind that interviews with children should be carried out in child-friendly environment in order to prevent re-traumatization of children. Barnahus model is seen as a positive example here, which is aimed at reducing stress in children and ensuring that children are assisted in any way possible in one-stop shop principle. Forensic assessment is not only the legal procedure, but is also the element of the process of protection of children's rights. Children victims feel not only physical trauma and physical stress, but also psychological stress, and therefore we have to ensure that legal process is not an additional trauma, but a way towards trust, which is helpful rather than traumatic. We need to find the most child-friendly ways to help a child in the justice system, and therefore we need cooperation, voluntary cooperation of all the institutions in conducting the interviews of victims. I hope that your conference will be active, productive, and interesting, and you will be able to learn from the experience of our foreign experts. And may you have a lively discussion. Thank you.
Dėkojom gerbiamam Juliui iš to.
Thank you, Julius, for your welcoming remarks. Let's continue our conference. Let me introduce myself. I'm Professor Dr. Jolanta Zenčkauskienė from Mykolas Romeris University, Director of the Institute of Criminal Law and Procedure. Just like Professor Rima, I'm broadly interested in all vulnerable participants of criminal proceedings, including children who are victims of sexual violence. Our agenda is broad, so we made certain changes to our program, but as a professional, I appreciate rules and order, and I would like to ask our presenters to stick to the timetable. I know your presentations are very important, but let's stick to the program. And if there's any time before the first coffee break, we'll have some time for a discussion. And after the second part of the conference, we will have another opportunity to discuss relevant matters and to ask some questions. So please write down your questions, and you'll be given the opportunities to ask those questions during our discussions. A short remark. I'm sorry, because we have a plenary sitting. We are discussing the budget for the next year, so I am unable to participate in the conference, but since the conference is being video recorded, I will have opportunity to listen to these presentations in the future. Let's continue our conference, and the first speaker is going to talk about Lithuanian experience, about child-friendly justice and court practices. It's Dr. Gabrielė Juodkaitė-Granskienė, President of the Criminal Division of the Supreme Court of Lithuania and Professor at the Department of Criminal Justice of Vilnius University. The floor is yours. Good morning. Thank you for the opportunity to talk in this conference. Let me at the beginning to narrow down our topic and focus on justice. And I would like to begin my presentation prepared by my colleague and me about court practices, and I would like to begin with some statistics which might look shocking, but this is the official numbers that we are working with, because we only work with cases that are legally assessed in one way or another. The trends are seemingly getting better, and according to the media, in 2018, the situation was worse than it is now. The most frequent criminal offenses are criminal activities are violence and similar cases. Victims of sexual violence are not numerous as well, although any number is too large in this case. So we're talking here about sexual violence. In 2014, there was 124 victims. Last year, we had 375, and the average number of the past 20 years is 230 victims. And my next slide will talk about children up until 14 years are victims of sexual abuse. The largest numbers of children who experience sexual violence experience that violence in their domestic environment. So this is our official data that are used by the Lithuanian police. They are graded in terms of different types of sexual offenses, and these numbers show the situation in Lithuania. Let me move on to the practice of courts and about evidence and the sources of evidence. Our situation and the situations that we work with are very difficult, and all judges, prosecutors know that we have a limited amount of data and sources of data that can be later acknowledged as evidence. Of course, the testimonies of victims are the most important, including the reports by psychiatrists and psychologists. And usually these experts' reports are carried out, and the expert's report is just a part of evidence. And you'll see in practice that courts can work without an expert's report. I'm not talking about forensic assessment. Let's continue with the court psychologists and psychiatrists. We can see that their roles are very important. They conduct independent forensic assessment. They support children during forensic interviews, because it's important to understand victims very well as the perpetrators. We have been discussing maybe we could compile these functions into one, and there's no single answer to this question. Because in our process, we have a lot of other rules and principles that we must follow. And one of them is right to defense. And we have to balance these very sensitive cases. Coming back to the information, it is our long-standing practice to treat the testimonies of victims as the main source of evidence. In addition to that, those testimonies cannot be treated as untrustworthy, and it also depends on the work of professionals, whether they can explain and ask appropriate questions during interviews of children. So the main principles have been formulated a long time ago. So we have basic requirements for those children testimonies, but there's an additional requirement of trustworthiness, and it depends on the level of development of a child, of the level of the distress that it's experienced by a child. And for these reasons, we need the help of a psychiatrist and a psychologist to assess the situation. So there are many different practices, and I have to note that children themselves view situations differently. There was a situation where a child came home with his glasses broken, and his brother and a boy said that it was their neighbor who did that to them because they refused to take his candy. And we did not need an expert's report because we could assess the situation adequately. We understood that the suspect is not aggressive. So we're assessing all of the aspects related to the suspect. We assess the physical condition of the suspect, the traumas that he had experienced, and we decided that the story was fabricated because boys were afraid of their parents being mad at them for breaking the glasses. There are some situations that are rather frequent, because sometimes the interviews conducted by psychologists are questioned. And sometimes there are questions why it is the psychologist who formulates the questions rather than the judge. And there were concerns that psychologists had prepared a child for the interview. But our recommendations are rather old, although we are updating them together with the Ministry of Internal Affairs and the General Prosecutor's Office. And we have a rule that it is the best practice when it is only one person, one professional who communicates with a child rather than a judge or an officer who asks questions that the child may not understand. And during the interviews, there should not be a number of people together with a child. Another aspect in this case is that when psychologists are supporting children, they sometimes affect a child and form their opinion related to the situation. However, there was a mom who noticed an unusual behavior, and she contacted a psychologist, and she was worried that a child was unfairly prepared for the interview. And the third case from our practice was when a psychologist was accused of giving a faulty conclusion. So it was denied because the assessment was not ordered by the court. It was submitted as a written document, and courts did not need an additional assessment or an interview which could cause more stress to a victim. Another practice of the Court of Appeals, just an example of that which could be interested for our foreign guests. Our experts talk about whether a person tends to be a liar, whether they have some impact of trauma, and they talk about the reactions of a child to the questions during the interview. Because courts, when assessing the evidence, focus on the trustworthiness of the evidence, and it needs to be assessed in terms of whether a child had a tendency to lie. And talking about forensic assessments and the role of them, during them we should assess whether a child has PTSD or certain other conditions related to harmful activities. And I have several examples, but I'll mention just one of them. We often say that a forensic assessment just one type of evidence and it's not obligatory, and very often we don't use forensic assessment. But I would like to remind that we have court's discretions, and we cannot determine the number of forensic assessments for year. The situation is very individual because we are working in the interest of a child. I personally really like this particular case. Well, I find it a little bit funny because it's not related to sexual abuse. When a teacher tried to tame the children, and a child said that the teacher hit them with a ruler. And several children testified the same thing. One girl in the class complained to their mom about children's behavior. She told her mom about the boy being allegedly hit by the teacher. And in this case, we did not need a forensic assessment because the situations were rather simple. And we could avoid having to conduct a forensic assessment. So that's what I wanted to say, and I would like to move to my conclusions. Because our systems sees psychologists and psychiatrists as help and experts who can conduct interviews in the most effective manner. And I would like to come back to the question, how can we maybe eliminate at least one step in the process, because we need to prepare a child for the interview, we need to assess the interview with the child, and we have at least 3 steps in some cases. So maybe some of those steps could be merged together, but this is a question to be solved by our system. And courts try not to abuse courts' discretions regarding forensic assessment, and we choose this particular path when it is necessary and it aligns with our process.
Ačiū gerbiama pirmininkė.
Thank you, Madam Chair, for this interesting presentation, and we continue our conference. And now I'd like to give the floor to the speaker on the crossroads of forensic psychological expertise in the best interest of the child. It will be presented by Professor Dr. Ilona Laurinaitytė and Professor Dr. Neringa Grigutytė from the Institute of Psychologists of the Faculty of Philology at Vilnius University. Neringa Grigutytė is a professor at the Institute of Psychology and the advisor to the Minister of Health. Good morning. It is a privilege to be here. We are not standard with our presentation, and I would like to apologize to the interpreters for that. I would like to address the judge. Well, in the court, when you invite psychologists or other experts, what kind of questions do you normally ask during the beginning Please don't shift the responsibility. Well, we have done that. Well, we work in the Supreme Court and we don't invite any witnesses. Well, this is really funny. We have judges of the courts of first instance. We will discuss later on. But I cannot start my presentation if you don't answer my questions. What type of questions are asked? Please let us not waste our time. Psychologists and psychiatrists who engage in conducting forensic assessment are invited only in cases when additional questions arise to the judge based on the report of the assessment. If the questions arise, then experts may be invited. Well, do you agree with me? Well, my experience shows, well, I'm not an expert and Ilona is not an expert on the expert list, but we have to verify our identity. But we have to explain why we have to have a right to provide a conclusion. And then we have to prove our expertise, our competences. I'm sorry, our presentation will be in a form of dialogue. Ilona, a question for you. The question is, do we have the right to speak about the crossroads of forensic expertise of psychologists and psychiatrists? I will briefly answer. Well, we are not experts, but for many years we work in this field. Why? Maybe you explain why. We're not only improvising, we have numbers and information on that, the crossroads and why. Many years we have been dealing with this same question. What are expectations from psychologists and what questions can be asked? Well, I will be brief. We heard about the Barnehus model. It was mentioned on several occasions. And with my colleague Evaldas Karmas, we've established the Child's Home or Barnehus Lithuania in 2002, which was later closed. We worked with children who were victims of sexual abuse, and we were funded by the Swedish Queen's Fund. We wanted to start the process that would later on would be taken on by the government. I was very active in procedural issues at that time and in creating the standards of interviews and assessments in order to ensure that justice is child-friendly. In Barnehus, Lithuania, I've been able to know Ilona, who brought her experience from foreign countries. For more than 20 years, we are discussing the same things, but they don't seem to be changed. We've achieved many things. Well, actually, I had experience when court cases were being processed and all the participants of the case had to participate in the court hall, and child victims were interviewed during the court proceedings in the presence of a perpetrator. But now the situation has changed. When we speak about law and psychology, which is the application of psychology in law, psychologists take part in legal proceedings and their experience or their knowledge is used for that. I will be speaking rather than reading. I'm very sorry for rushing. Well, first of all, we had the psychiatric forensic assessment, then psychological forensic assessment. But drawing from our history, psychology is a new thing that was introduced in Lithuanian law. Psychological conclusions are based on probability, and this is not very acceptable for law because law is an exact area. Well, we had the psychiatric forensic assessment first, and psychologists were just assistants in this process. They made certain evaluation tests, and the psychiatrist was the main expert in the assessment. And later on, the system was changed, and psychologists became independent, and their conclusions could be provided independently from that of a psychiatrist. We can discuss the interview rooms that were established in 2004. The first interview room was established. And sometimes such interview rooms existed in police stations, and the interviews were not conducted according to the requirements. But sometimes we still face challenges here because we still have interview rooms where children are interviewed in front of a police officer who is typing on all the information on the computer. The first interview rooms were established in courts, but we had no financial and human resources for them. Now we see the falling number of psychologists, forensic psychologists. We have a list of psychologists who assist in courts. I think Ilona would like to comment. In so many years, well, foreign colleagues would be interested in that. We have interview rooms for 20 years now. And it is important to underline that we had experts and we had support from different institutions and NGOs. Last year, we celebrated the 10th anniversary of experts within courts, which is a great step in the Lithuanian legal system. And based on the best interests of a child in criminal and other proceedings, well, unfortunately, the reality shows that the number of psychologists is on the decrease, and we have only 10 psychologists, whereas we used to have 17 in the past. Yesterday, we've heard the description of the situation where we have a new system of shelters. In 20 years, we have not learned from the mistakes of our past, and we are again at point A. Well, that was a brief introduction of our history. We'll speak about the crossroads. Choosing or not choosing the assessment. We actually see a great need of that. And sometimes we're faced with the challenge that there are long queues for getting forensic assessment reports. And sometimes it can take 8 months before the assessment can be made. And sometimes we even see the headlines in the media where justice is being delayed for children who are victims of sexual abuse. And for example, we have cases when children are abused when they are 7 and they are being interviewed when they are 10. And this is the delay of justice for children. These are the headlines on Facebook news portal saying that a lawyer is looking for forensic psychologists and psychiatrists who are experts in the field and are not afraid to name the abuse. And here we're faced with another challenge, is that we need to engage in education. We can really hear about the need of and demand of that. Well, the first element which is very important here is the qualifications and training of forensic psychologists and psychiatrists. Well, this is a document which is very old. It dates back to 20 years ago. It was signed by all the heads of the departments of psychology of Lithuanian universities. This document discussed the need of forensic, psychological, and psychiatric assessments. And we had some opposition to that. One of the main issues or questions was who would be responsible for the training of experts and for including them on the list of necessary experts, forensic experts. University representatives also asked the permission of including universities into the training of experts. Now we have graduates of universities. They can really be employed in different services, but they have to retrain and to gain additional training. We had a recent scandal when experts were sent to Moscow to Serbsky's Institute for training. Another problem is that we see the lack of experts. This means that we need more people, more human resources for the court psychiatric service. people work very hard and long hours for the benefit of the children in this service, but we need many more experts in the field. And another issue is that questions that were formulated 20 years ago on the activities of forensic experts does not coincide with today's reality. And therefore, this leads to different arguments on the quality of experts and whether these experts can participate in court proceedings. So the task is really to have a clear vision and to have a clear path and strategy in this area. I have raised a lot of questions during my presentation, and if we consider every question, it would take us all day. The question today was raised on whether we need assessment report in all the criminal proceedings and in all other proceedings. Sometimes we might have expert conclusions which are sufficient, and sometimes forensic assessment is necessary and is being ordered. And unfortunately, experts cannot answer the question whether a child can be lying. Well, the issues that are still a cause of concern for us is that evidence and science-based methods of interview and assessment. Sometimes experts are asked why do they know that a child might not be lying? And another issue that we face is whether assessments are in line with the best interests of a child. Barnohus model in Lithuania does not correspond to the models of other countries because they don't have an in-house expert that would work there all the time. When the need arises, an expert is being invited and is a passive participant in the process. And that brings us to the end of our presentation. We hope that we have stuck to the timetable.
Ačiū. Nežinau, ar čia teisėjai išlaikė egzaminą.
Thank you. There were so many questions asked, but what our colleagues are talking about, it's our everyday work for all of us. I'm talking about standards and the methods for research and judges and other legal professionals who, based on experts' conclusions, have to make certain decisions. Therefore, questions regarding the experts' competences are very important. And it has to do with the interest of a child. So there are so many questions for discussions, and we have no answers to those questions. And I would like to continue our presentations with a presentation by Ingrid Thorsen, a prosecutor from Norway, and she's going to talk about police interviews of children as victims in cases of violence and sexual abuse and how these are used in court cases. So let's come back to the law.
Thank you, ladies and gentlemen. I'm very, very pleased and honored to be invited here today to talk about how we in Norway conduct forensic interviews and how these interviews are handled in court. I have worked in the police on cases involving children as victims of sexual abuse for 20 years. I lead investigations and I lead interviews at barnehus. As a prosecutor in the police, I also have experience with how these interviews are handled in court. I am a spouse, I am a sister, and I am a grandmother. And I'm living outside Kristiansand with my husband, a dog, and a cat. It is part of my responsibility to ensure that the police take care of both the best interest of the child and the legal rights of all parties in the case. Barnehuset is a very, very important partner for us. The Norwegian legislation for forensic interviews also covers the group of victims who have intellectual disabilities or similar functional impairments, regardless of age. My presentation is simplified and focuses on the main points. My presentation is limited to cases of violence and sexual abuse. The interviews as a part of an investigation, the use of the interview as evidence and the suspect's rights, and I will say something about who assessed the interview as evidence before the trial and assess the credibility in court. The legal framework in Norway, can you see here, about interviewing children in cases of violence and sexual abuse. In Norway, we conduct both ordinary police interviews of children at a police station and interviews at barnehus. In cases of domestic violence, different kinds of severe violence and sexual abuse, the interview must happen and must be conducted as an interview at barnehus. This applies both to the victims and the witnesses in these cases. We can conduct this kind of interviews in other cases also, if it is in the best interest of the child. An assessment is then made of the seriousness of the case and the child's personal circumstances. I want to mention some key elements. It's the best interest of the child. The child welfare services must be given the possibility to be present and involved. It's not required that they shall always be there. They decide themselves if they want to be present at the interview at barnehus. As mentioned, it must be carried out at barnehus. The barnehus will ensure that the police take the child's best interest into account. The child's rights is important, the child needs, and the rehabilitation as a victim of violence or sexual abuse. The testimony is the child's testimony in court, and the suspect's rights shall always be safeguarded in our proceedings. There is an age limit of child interview at barnehus, that's 16 years old. but it's 18 if in cases of sexual abuse by a close relation. We have two types of interviews. This is first interviews and this supplementary interviews. This is the key actors when we conduct forensic interviews at barnehus. A prosecutor from the police, an investigator, and the interviewer, also the police interrogator who conducts the interview, counselor or advisor from barnehus, and the legal counsel for the child. In most cases, generally, the suspect is not notified in forehand and cannot attend, also be present, and cannot ask questions at the first interview. In most cases also, the defense counsel has no role at the first interview. Before the first interview, the key actors cooperate about preparing the interview, which person should bring the child to the barnehus, how do we ensure the best interest of the child in the preparation and during the interview and after the interview. And we gather information about the child's functioning, the child's living situation, personal situation and background. We plan the interview and the entire day that the interview takes place. We prepare alternative plans depending on the content of the child's story, also for the situation after the interview. The interview is at the barnehus and it must take place within 1, 2, or 3 weeks, depending on the case category. It's always conducted by a police investigator who has a special training in talking to children. It's a specialized education in the police. And the police interviewer always have to make a formal report of all contact with caregivers or the person who brings the child to the barnehus, and contact and communication with the child before the interview. The interview is video recorded, and we also get a full transcript of the dialogue. The interview can take place another place than barnehus, but the barnehus and the prosecutor have to agree on that, if it is in the best interest of the child. Some children not want to go to barnehus. Institutional children maybe, or yes, sometimes that happens. Who is leading the interview at the barnehus? That's me. That's the police prosecutor. It's my special responsibility to ensuring a clear and truthful account, including facts that both support and challenge the suspicion. And the other actors, persons you see, the roles you see here, is also present in the separate room observing the interview. Those who can ask questions to the child is the police prosecutor, the victim's lawyer, as in court, and the investigator also have the opportunity to ask questions to the child. Can we have one or several first interviews? Yes, we can. We can conduct the first interview over several days. We can conduct multiple first interviews. Some children cannot tell the story in a single day. They may be sexual abuse or violence over many years. And to expect that a child should tell this in 1, 2, 3, 4 hours in one day, it's too much. So we have to have the possibility to make it happen over several days. Key factors will be that the child has not finished explaining themselves or that new information has come to light about what happened. There may also be factors that make it difficult for the child to talk about what has happened, and we have to consider that. After the first interview, the child's parents and or other caregivers are informed. We cooperate with the child depending on the child's age, what to say. Children that are victims of child abuse or other offense can decide itself whether the parents or other caregivers shall get the information about what the child has said. But we can decide that it's in the best interest of the child that we'll have to tell something anyway. After the interview, ska se, where were we now? Yes, we have to also need to determine whether measures must be taken to protect the child after the interview. And the police prosecutor must consider whether the suspect should be formally charged after the first interview. This is a preliminary charge during investigation. If there is a qualified likelihood that the suspect is guilty after the first interview, it requires at least 51% probability. The defense counsel must be appointed as soon as possible, and the suspect and the defense counsel must be given access to the interview and all of the case documents. We have to formally inform the suspect about this that you see here. Which child has been interviewed at Barnehus, that he has been formally charged, that the video will be played in court, that the video of the child's personal testimony is the video, and the important thing is that the suspect may request a supplementary interview and ask questions to the child. The suspect and the defense attorney has to formulate specific questions to the child. They cannot say just, I want another interview. They have to write to us, what kind of questions do you want to ask to the child? And we have to get the answer on these questions in a set deadline. It can be in 2 days, 1 week, but the supplementary interview shall, according to law, be conducted within 1 week after the first interview. We are a little slack about that, but that's according to law. The suspect may not ask questions, are not allowed to ask questions that imply that the child is lying, or questions already answered by the child. The supplementary interview. The child has not to repeat what is already said. It is the questions, the supplementary questions, the additional questions that the suspect want to ask the questions and ask the child. And as a prosecutor, I can also have some question to the child then. New or clarifying questions, and the planning is in the same way. And the defense counsel is now present. It's my experience that in most cases, defendants do not request a supplementary interview. It's my humble opinion that part of the reason for this may be the requirement to formulate questions, specific questions, that supplement the first interview. Because then it's a bit more, yes, you have to be on point on what you ask the questions. They say, I just want another interview. And in that way, the legislator has decided that the child should not have to repeat the story at any time. Can we have multiple interviews during investigation? Yes, we can. If new information, if there are issues the child has not addressed, the defense attorney, the police, the child's lawyer can all request another interview if there is new information or other circumstances. Factors that have to be considered then is the accused rights, the best interest of the child, and the facts of the case. Before the investigation is concluded and there will be a trial, we have to control and secure that the suspect has had the opportunity to request another supplementary interview, and we must any gaps must be addressed before trial. The defense may request that experts, witnesses, access the interview and documents, but the experts never meet the child. If someone has some new questions, it is the child, then we make another interview in the same manner that we did before. The child interview in the trial. Children that are under 16 of the date of the trial, the video interview replaces personal testimony. The court receives a full transcript of the interview in dialogue. Children who have turned 16 before trial, the interview still replaces personal testimony. The court may order the child to testify in person, but that's rare. Even then, any in-court testimony is only supplementary. Some children of age of 14 or 15 want to meet personally in the court and answer any supplementary questions. But they can decide themselves, and it's rare the court decide that they have to meet. Key factors for the court's assessment are the defendant's right to a fair trial and the child's well-being as a witness and clarification of the case. When psychological expert witnesses, there is up to the court to assess the credibility of a witness statement, including this type of interviews. This is part of the court's evaluation of evidence. Defense may request such witnesses, but the court always decide whether the expert may testify and what the expert may comment on. The Norwegian procedure does not require that expert witnesses assess the credibility of a child interview prior to or during trial. I have the court consistently hold that the credibility assessment is the court's responsibility. Sometimes the court say, the judge say, experts may testify. The experts may testify only if the court finds it necessary, and the expert never interviewed the child. They review only the video and documents. Here is some statements from Supreme Court cases, and as you can see, they hold that it's the court's responsibility to assess the credibility of the child's history and the interview, but they opened, it's a possibility that, that expert witnesses may guide the court, and if it's occur additional questions during a court trial, then you take a pause in the trial and ask the police to take a supplementary interview of the child at Barnehus, and the same way we always do. And then the defense lawyer is present, and we ask the questions, and then this supplementary interview is played in court when it starts up again. So, thank you very much for your attention.
Labai dėkojame už tokį.
Thank you for this clearly structured presentation. I believe that the lawyers have seen similarities with the Lithuanian system, but certainly this strict position, preliminary questions and additional interview is something that can give food for thought to our procedure. Well, Lithuanian judges also use their discretion to decide which is needed during the court proceedings when new facts transpire in court. So, in general, good interviews of children are considered to be trustworthy, and if videos or audio recordings are presented, they are normally considered as trustworthy. And now we are running a little late, and we are postponing a coffee break. Therefore, I would like to give the floor to Kim Risumos with Morter Jarmer, colleagues from Denmark, from Barnehus in 2 cities, and they will be speaking on the topic of from police investigation to trial. So the floor is yours.
Yes, thank you so much for having us here. It has been a pleasure so far to hear all these fine presentations, both yesterday and today. Obviously, I didn't quite know what to expect when I got here, but I must say that this well-organized conference has given me good inspiration and knowledge to bring back home. So thank you for that. What I expect to give you today is a short introduction to the path from the very start of a case where a child is suspected to be exposed to violence or sexual abuse. And the police will start an investigation, and experts will do their best to assess the child in any way that is needed, bringing their knowledge to the court if asked, and providing security and treatment to the child if this appears to be in the best interest of the child. I'm not a police. I'm not a prosecutor, but I witness the everyday practice on sending my employees to the court as expert witnesses when we are asked to do that. That would be my background for comment on these topics. Video recorded forensic interviews of children who act as witness in their own cases are a central method for protecting children from traumatizing and stressful experiences within the legal system. The purpose is to create a gentle process where the child's best interest and the legal rights of all parties are highly prioritized. Forensic interviews allows the child to avoid physically appearing in court and ensure that the interview takes place in safe and child-friendly surroundings. At the same time, it is crucial that legal safeguards are maintained through correct legal procedures and the participation of both the defense attorney and the victim's counsel. One of the main principles of video recorded forensic interviews is the protection of the child from repeated and stressful questioning. This process ensures that the child is not exposed to unnecessary psychological strain, while the defense attorney and victim's counsel participate to ensure proper documentation and a fair process. The procedure and the forensic interview must balance the child's best interest with the rights of the accused, maintaining fairness and legal integrity throughout the process. The decision to conduct a forensic interview is made individually, based on the child's age, the nature of the case, and special circumstances. And of course, it is the police that make that decision. Both Danish regulations and EU directives set the framework for forensic interviews of children. EU directive emphasizes that children must be protected from trauma during legal proceedings and that interviews must be adapted to the child's age and maturity in safe environments. Denmark has mandatory video recorded forensic interviews for children up to 14 years. That's a little bit different from Sweden and Norway. The implementation of EU directives varies from one country to another, reflecting differences in national procedures and cultural approaches. The process begins when the police receive a report and assess the need for a forensic interview of a child. Consent is obtained from the holders of parental authority, or a decision could be made in court. The forensic interview is planned in a child-friendly room in Barnehus with the participation of the defense attorney, the victim's counsel, and possibly a child expert. The entire interview is video recorded and included as evidence in the case. As a rule, the child is exempt from appearing in court. The procedure is described in the guidelines of the Director of Public Prosecutions and in the Administration of Justice Act in Denmark, and it is carried out in close cooperation between the police, the prosecutor, the social authorities, and the staff of the Barnehus. By following both national and international guidelines and prioritizing the child's well-being and legal safeguards, a more caring and legally correct treatment of children in legal proceedings can be ensured. Ongoing development and interdisciplinary cooperation are central elements in strengthening the process and protecting the child, the rights of the child. Building on this, harmonizing practices for forensic interviews of children across countries can significantly strengthen the children's rights. Consistent procedures help ensure all children receive the same protection and support, regardless of where they are. It also improves cooperation between professionals and leads to more reliable evidence. Aligning with international standards makes the process more fair and more child-friendly, benefiting both the child and the justice system. I think in Denmark you could have in mind what Ingrid just told about the Norwegian process. In Denmark, it's mostly similar to Norwegian. Few differences, but also mostly the same. But also, expert witnesses can have a crucial impact on the child's case. This part of the presentation provides an overview of how expert witnesses are used in Danish court cases of violence and sexual abuse of children. We look at the role of the forensic pathologist, the psychologist from Barnehus, and representative from the Child Protection Service, and general rules for expert witnesses. The purpose is to create an understanding of how these professionals contribute to the information of cases, ensuring legal certainty and support for the child. Expert witnesses play a key role because cases involving children often lack hard evidence and the child's testimony alone may be insufficient. Therefore, professional documentation and assessment are crucial to strengthen the evidence base and ensure a fair process. The presentation is structured in 4 main parts that highlight the function of each actor and the legal framework for their duty to testify. We also touch on how confidentiality is handled and how the court can lift it when information is of crucial importance for the outcome of the case. Forensic pathologists have a crucial function in cases of violence and sexual abuse of children. They conduct physical examinations and document damages, which can be the most important evidence in court case. In Denmark, however, there is a major challenge. Only a very small percentage of children who are a part of a case handled in Barnehus are physically examined by a forensic pathologist. Statistics show that only about 5% of children in such cases receive a forensic examination, which create a significant difference in legal certainty between children and adults. Projects such as systematic forensic screening have shown that standardized screenings strengthen the evidence base and can reveal both current and past damage. These examinations are particularly important when the child is very young, has a language difficulties or disabilities, as objective evidence can support or disprove the suspicion of abuse. The forensic pathologist statement can thus be decisive for the court's assessment and ensure that the child's statement does not stand alone. Psychologists from Barnehus can be called as witness in court when their professional knowledge is relevant for the investigation of the case. The summons is typically made with the court or the prosecution service, and when you are summoned, you are obliged to appear and give evidence under oath. Psychologists normally have a duty of confidentiality, but the court can revoke this if the information is deemed to be of crucial importance for the outcome of the case. This is regulated in Chapter 18 in the Administration of Justice Act in Denmark. The psychologist's testimony will typically deal with a child's reactions, behavior, and assessments of trauma, but not a conclusion about guilt. The psychologist acts as a professional witness and contributes with insights into child's mental state and needs, which can help strengthen the understanding of the child's statement and experience. It is important that the psychologist's role is clearly defined so that the testimony does not exceed the boundary of assessing the question of guilt. Social workers from Child Protection Services can be called as witness in court as well. These cases concerning violence and sexual abuse of children. As a general rule, they have a duty of confidentiality, but also here the court may set this aside if the information is crucial for investigation of the case. Consent from authority may be necessary, but the court may require an explanation if consent is denied. The social worker's testimony will typically deal with the causes of the case, notifications, and what measures have been taken to protect the child. They are expressing themselves about actual observations and decisions, not about blame. Their insight can be important to shed light on how the authorities have handled a case and whether there has been a proper follow-up on concerns for the child. This information can help to uncover the system's reaction and any failures, which may have an impact on the overall assessment of the case. So, expert witnesses may be appointed by a party summoned by the prosecutor or the defense counsel, or appointed by the court. The purpose is to provide the court with professional insight into medical, psychological, or social conditions in which judges and jurors do not have expertise themselves. The rules for expert witnesses in criminal cases are not regulated in detail, but practice follows provisions of the Administration of Justice Act and the court's guidelines. Expert witnesses must give evidence under oath and may be required to testify if the court considers that the information is of crucial importance for the outcome of the case. Confidentiality, as I said, may be waived by the court in special circumstances. Expert witnesses do help to ensure a fair trial, providing specialized knowledge that can support or refute evidence and statements. Their role is not to determine guilt, but to inform the court about professional aspects that are important for the assessment of the case. So, what I was hoping for was that I managed to include the last part of my presentation within the time frame. So I can say a little bit about a special project we have, and I mentioned it earlier, the forensic screening project, and it is conducted from Barnehus, Copenhagen. From 2020 to 2022, Barnehus, Copenhagen ran a forensic screening project in collaboration with the Forensic Institute, Copenhagen Police, and of course Barnehus, Copenhagen. The goal was to detect child physical abuse earlier and strengthen the evidence for legal cases. Previously, examinations were rare unless requested by police, leaving many cases undocumented. By making screenings as a standard for children participating in forensic interview about suspected violence, the project improved investigations and child protection. It also introduced new cross-sector communication protocols and professional training, ensuring better handling of sensitive cases and supporting Denmark's broader efforts to protect vulnerable children. The project aimed to achieve two goals. One, detect early signs of violence against children, and two, support police and social services with objective medical evidence. To accomplish this, all children interviewed at Barnehus, Copenhagen for suspected violence were offered forensic screening. Unlike previous practices, where screenings were rare and required police request, this systematic approach ensured consistency. Examinations were carried out by specialized forensic team in child-friendly facilities, including physical assessment, injury documentation, and recommendations for follow-up. New communication protocols and family information materials improve transparency and trust. This structured process enhanced data collection and helped uncover patterns of abuse that might otherwise remain hidden. The project showed that systematic forensic screening is crucial. 25% of the examined children had visible injuries. 28% of the children had abnormal findings linked to reported incidents, and 29% needed further health follow-up. Very few children refused the exam, showing high acceptance, and these results reveal much undetected abuse and highlight the importance of broader screening to protect children effectively. The systematic screening project improved both legal and social services by providing objective medical evidence, strengthening investigations, and reducing reliance on children's testimonies alone. This led to better case outcomes, earlier identification of children's needs, and more effective agency collaboration. This project set a new standard for evidence-based child protection and demonstrated the value of integrating forensic expertise into multidisciplinary teams to safeguard vulnerable children. The key recommendations following the project's success is make forensic screening mandatory in all suspected child violence cases to ensure consistent protection. Scale up and implement the Barnehus Copenhagen model nationwide to close systematic gaps in child welfare and legal processes. Secure ongoing political and financial support. And for now, the government has already allocated 15 million Danish crowns annually to strengthen the efforts against child abuse, including expanding the forensic medical screening programs. That will take place in 2026. These steps aim to embed best practice, improve interagency collaboration, and guarantee every child receives proper protection. Future priorities include refining protocols through research and continuous professional training. By adopting these measures, Denmark can lead in creating a safer environment for children and inspire other countries, maybe. Thank you for your attention.
Labai ačiū, kolega.
We thank our colleague. Unfortunately, we don't have any time for questions. Of course, the presentations were very interesting, but let's postpone the questions for the discussion part. But I would like to invite everyone to have some coffee and go for a break. And although we have already spent 10 minutes of the break, I would like to ask everyone to come back to the hall 12:15, because many of our guests are visiting us from other countries, and we have to stick to our schedule. So please come back 12:15.
Sakė, pradėk, nebelauk. Jau laikas praėjo. Ir net ir pavėlavom jau. Aha, puikiai. Oi, atėjo Audronė va prie tavęs kaip tik.
Mūsų Jolita sėdite.
Ai, Jolita. Jolita? Jolita? Tai turbūt visi, kaip sakyti,
Welcome back after the coffee break. Welcome back after the coffee break. I hope that you had a nice coffee. Let us continue our conference. And in this part of our conference, I would like to give the floor to the Finnish representatives from Barnahus in Finland, and the presentation is on crimes against children and multidisciplinary cooperation. The presentation will be made by Sara Asmundala, the Finnish police superintendent, and Sinne Stolt, senior specialist at Barnahus, Finland. Please, the floor is yours.
Thank you. My name is Sinne Stolt, and I'm starting here, and Sara is going to continue. I tell you, could you next slide? Yes, I'm going to tell you a little bit about how we have been implemented this model and how, in what situation we are now. This house building is, like most Barnahus buildings, our Finnish illustration about this. And our first units were established in 2008. And as other countries, we won't work under one roof because Finland, we have few people in a large country. So that's why children would need to travel so far if we only had 5 buildings. So we make a net around the children and move where the children are living. After our first Barnahus houses, we had this screening project we are going to tell you about, and you will get the papers also. And then now I'm leading the Barnahus project, which has developed work further with all the rooms and also services nearby Barnahus model, like daycare and school services. And now we are in current situation that we are going to have a new nonviolent childhood program for next 8 years. It's over our parliament decades. So we get good support also from political side to our work. And then we have becoming a new law, a new Barnahus law, where it's going to be all the children under 18-year-old and all the crimes against children, and also most difficult divorce cases are in the future Barnahus customers. And also we get the new law base for the information sharing in multidisciplinary work. And then also better national coordination of the Barnahus work. And also children who have witnessed the crimes or are suspected of making a crime. But Sara will tell you more about everyday life work and how this is done in Finland. So Sara.
Thank you. I'm honored to be here to introduce our implementation of the Barnahus model. I work as a Barnahus police officer in Finland. I used to be head of investigation of crimes against children, and now I'm employed by the National Police Board, which is the highest level of administration in police in Finland, and we guide and instruct the police departments. But here is a slide of our workload. This is all the reported incidents of suspected crimes against children in the past 5 years. We have seen a significant increase in the number of reports. Of course, we all know that this is not the whole truth. This is just the reported incidents. But the increase has been significant, almost 40% from the year 2020. Last year, in 2024, we had about 5,000 reports of sexual crimes against children and about 10,000 reports about physical abuse against children. And just to remind you, Finland has, I think, an exceptionally low threshold for reporting. So basically, any suspicion of violence or abuse against a child has to be reported to the police and the child protection services by law. And also we have the least, this is something that I'm not proud to say, but we have the least number of police officers in Europe in relation to the population. So we are forced to be effective and we have to use our minimal resources wisely. But this is how we do investigations in crimes against children. This used to be a model for investigation of sexual crimes and physical violence, but we expanded to all kinds of crimes, including trafficking of human beings, for example. The bedrock of this model, I have to say, is the preliminary assessment of the report when it comes in, and the multidisciplinary work, which was at the center of the Barnehus house you saw, is vital, and it begins at this preliminary assessment stage. Over half of the cases are investigated, at least to some extent, if not to in full measure. But there are cases where the route is different for the case. I will explain these different routes in more detail in the following, but I have to stress that whatever choice is made for the route for the case, it's made with the best interests of the child in mind. That's always like in the background of our decisions. So the preliminary assessment is crucial, and it's vital that we have sufficient information on the child at this point when we assess the how serious the suspicion is. And also in Finland, the head of investigation is police, not prosecutor, but cooperation with the prosecutor begins already at this stage. We are obliged to notify the prosecutor, and we do it gladly because we need that cooperation. Yeah. And also child protection services are a vital part of this process. So the exchange of information begins at this stage already. And also we have to consider whether the child can be represented legally by their guardian, or whether we need a guardian ad litem, someone to replace the legal guardian if they are, for example, suspected of the crime. And the background form that we used to evaluate the child's background information has just been revised, and Sini will hand out the English translation of the form. If we have time, we will explain it in more detail later, but just to put it shortly, it's our way of doing a risk assessment and also assess the case and the child's situation. That's at the base of the form. And the form is filled in by a social services expert or professional, or a healthcare professional, and for the use of police and prosecutor. And also the form can be used by child protection services as well. But the main goal of this preliminary assessment stage is to find the right path for the case in this model, or always with the child's best interest in mind. Like I said, most of the cases will be investigated, but there are more complex cases where we really need to get together, sit around the same table with this group, the multidisciplinary group of professionals. We have created criteria for this meeting of professionals. For example, if there are current reports of the same family, they're kind of complex. We are not sure whether it's in the child's best interest to investigate or not. We can discuss it with this meeting. We all know that difficult divorce cases or custody disputes are very hard on us, so multidisciplinary assessment is often needed in those. And also, well, basically all cases where we are not quite sure whether to investigate or not and what path we should take, then we need this compiled wisdom from this multidisciplinary meeting of professionals. And also there are those few cases where we can terminate or discontinue the investigation. For example, if the constituent elements of a crime are not present, like something is reported to the police as a crime, but it's not a crime from our point of view, and the prosecutor is also part of this decision making. So some decisions can be made by the police and some by the prosecutor, but we always cooperate, no matter what the end result is. So we don't terminate an investigation in a crime against a child without cooperating with the prosecutor first. And then the actual pre-trial investigation, I will not go through that in detail. You are well aware of the measures that we can take. I will just say a few words about child interviews in Finland. We have a very extensive training for police officers and forensic psychologists for interviewing children. They actually attend the same training, so they are equally educated in this. The training is coordinated by the police university college, and it lasts a full year. Not all the time. The people go to work in between the meetings, but they conduct interviews, and their interviews are not torn to pieces, but they're analyzed in this course by professionals, and they get feedback and so on. So it's very, very fruitful. And it's especially fruitful to have all these different professionals together, doctors, psychologists, police officers, social workers. That's, we find that very, very useful. And all interviews of children under 15 are recorded on video, and most of those under the age of 18 also. And we use the National Institute of Child Health and Development protocol for the interviews as well. Here's an example of our interview rooms. They're very stripped down of any distractions, maybe a bit too aesthetic, but anyway. I can't stress enough the importance of the right to exchange and obtain information on the child. It's crucial, it's vital that all the relevant authorities working on the case have the right to exchange information. Like Sini said, we have some new legislation on its way. Currently, we are, I would say, quite well equipped with these rights, but it's getting better. But basically, the guardian can give consent to the access of information, or the guardian ad litem appointed for the child. But other than that, we can, as police, we can obtain the information on a child if it's from the social services, if it's a crime that has a maximum penalty of 4 years of imprisonment or more. And the healthcare information is more protected. We need a crime with 6 years maximum penalty of imprisonment or more. But if we work with the Barnahus units, they have a very good legislation at the moment, as it's getting even better. we can access all necessary information in spite of the maximum penalty of the suspected crime if we ask the Barnahus unit to collect the information. About 10% of children are interviewed in Barnahus units, the rest are interviewed by the police, but even in the cases where the police conducts the interview of the child, we cooperate with the Barnahus units. They help us plan the questions, plan the interview, and so on. I have two cases of incidents where the case did not proceed to prosecution. This is just to show how that multidisciplinary work is conducted even if the case does not go to court. In the first case, there's a suspected sexual abuse of a child. It began with a report from a school nurse. She reported to the police that a 13-year-old girl had told her that she might be pregnant and had told that she had had intercourse with an adult male. The age of consent in Finland is 16. So obviously this is a suspected crime, a sexual crime. So we asked for the girl's background information using that form that you were given, and we cooperated with the Child Protection Services, and we found out through that cooperation that the girl was not, in fact, pregnant. We attempted an interview of the girl. She came, but she refused to tell anything. She didn't disclose anything about the suspected crime or the suspect himself. We used other means that we have. We seized the girl's mobile phone and we went through the data. We found a suspicious chat on Snapchat, the infamous Snapchat, and to us it looked like the girl and the other person were in some sort of relationship, but it was unclear whether it was a sexual relationship. So we concluded with the prosecutor that without the girl's own contribution, we were not able to continue the investigation. We didn't have enough evidence to prosecute, so the prosecutor terminated the investigation. Another case is of a suspected physical abuse of a child. This report came to police from the Child Protection Services, who had been contacted by the father of this 8-year-old child. The father had told that the child disclosed being afraid at mom's home. He was afraid of the mom's new boyfriend who had made some sort of threats. And that it was reported to us. We obtained a guardian ad litem for the child because the mother and father couldn't represent the child. We found out that the child has had ADHD and some sensory defectiveness, and Dad denied these claims. Mother denied these claims. She said that her new boyfriend was actually a kindergarten teacher and well equipped to raise up her child. We had this multidisciplinary meeting of professionals, and we concluded that it was more about a mutual lack of trust between the parents than an actual crime. And we decided that the Child Protection Services would continue to monitor the situation, and the investigation was terminated or discontinued. Just to mention about our handbook for investigation of violent and sexual crimes against children, this is being updated at the moment, but we have found it important that it's public, so it's available to all people online in Finnish and shortly in Swedish as well. It's a handbook for police mainly, but it's public as well. Okay, Sini will conclude with some information about the form that you received.
Yes, we have been developing the form over 10 years, as you heard earlier, that we have many projects on that, and now we are in that situation that it will be on the law, and also in the law will be established that the multi-professional team who is dealing with the screening form can use the information of it
in own decisions. So that's very good for us. And there also, this is evidence-based material. It's based on research. For example, the risks there is, you can cross like this, and we are now getting in the law those LASTA coordinators. So there will be a new profession in our barnahuses that gather up all this information of the child for the police. And always it starts from the request of the police, not from the request for child protection services or otherwise. And we have now, with Sara, running all around in Finland, all the police stations. Sara is going to go there tomorrow or Thursday, I don't remember. The last one is coming. So we are educated to police, barnahus units, prosecutors, and also those LASTA coordinators that we hope that everybody is going to work in the same way. And also we are going to get this in the, how you say it, in the police website, or how would you say it, that we are going to get this electric?
Yes, you can fill this in via the police's website, where you can report any crime, or where you can find any form that you would use to pass some information to the police. It's going to be there, so when you fill it out there, the information goes to our crime report system electronically, so we'll no longer printing out these paper forms.
And then there is also, we don't now take all our slides, but you get our presentation. There is a little bit more about how child protection services can use this, and also the harm assessment and everything. So you can contact us later if there is something you want to ask more. Finnair cancelled our flights, and we have to reorganize everything, and we are now flying to Sweden today and hopefully in the evening also to Finland. So that's why we are disturbing everybody's schedules today, but hopefully you got something, and you can contact us if you want to know more. Thank you.
Thank you. Ačiū.
Labai dėkojom pranešėjom.
Thank you for your interesting presentation and also the information that you have provided. We really appreciate your efforts, and every contribution and material strengthens our information sharing. So thank you once again, and safe journey home. Safe journey home and quick journey home. Now, on our program, we have a presentation, Children as Victims in Iceland, a prosecutor's and police perspective. And this presentation will be made by Daniel Reynesson, if I pronounce the name correctly. He's assistant prosecutor in Southerners Police Department. So the floor is yours.
Hello, everybody. My name is Daniel Reynisson, and I'm an assistant prosecutor at the Suðurnes Police Department. And if you've ever been to Iceland, Suðurnes is where the international airport is, and where we had the volcanic eruptions over the last few years, and the Blue Lagoon. And I'm gonna talk a little bit about the police and prosecutors' perspective in Iceland. So, firstly, Barnahús in Iceland was established in 1998. And here on the screen, we can see a picture of the current Barnahús in Reykjavík, the capital of Iceland. And as you can see, this looks like a perfectly normal house and is located in a normal residential area. And there is nothing really like institutionalized about it. And the thinking behind Barnahús is that it's supposed to be a one-stop shop for children who need it. It's a specialized place where the court and police interviews of children take place. And these interviews are both for children who are victims and who are witnesses in ongoing investigations. And then Barnahús offers also ongoing help and assistance for children. And an important thing in all things related to Barnahús is that it's supposed to be a child-friendly environment all the way through. And here we can see the main services that Barnahús in Iceland provides. And then it all depends on each situation and each child which services are needed. And we can see that there is victim therapy, medical exams and evaluations, interviews, family counseling and support, consultation and advice to local child protection services, and education and training. And in this presentation, I'm going to focus on the interview or the court statement that are performed in Barnahús. The main rule in Iceland is that a child gives one statement, but that is not without exception though. For example, if a new information comes to light and the child has to be interviewed again. But the main rule is one statement. And what is important to remember that this is a court hearing and counts as a valuable evidence. This is performed in Barnahús, and then there is a teleconference equipment used for all other attendees. And this interview is performed during a police investigation, most often in the early stages, to get the testimony of a child as soon as possible. Here we can see the interviewing room. And this is where the child and the interviewer, which is a specialist working at Barnahús, a child psychologist, they sit there and conduct the interview. And there is nobody else in this room unless the child needs an interpreter, then he is present as well. And there are microphones and cameras that are small and located so the child does not notice it very much. And the interview process is mainly as follows. First, the police prosecutor sends a request to the district court for an interview of a child. And this is, like I said before, most often in the early stages of an investigation to get the best and freshest testimony from the child. The district court sends the request to a certain judge, which orders a court hearing and calls everybody involved to a court hearing. And then the interview is performed, and the child and the interviewer, they are in the room we saw before, and all other attendees, they are together in a separate room, which is most often a courtroom, or sometimes a meeting room in Barnahús. And they all watch and listen to the interview via teleconference equipment. And here we can see who is present. The judge is always in control of the court hearing. Then there is police prosecutor, along with investigator, a lawyer appointed to the child, defense lawyer appointed to the suspect, and always Child Protection Service representative. The suspect itself, they are never present, only their lawyer, and if possible, we try to make sure that the suspect is not aware of the interview beforehand, so he has no chance to affect the child. And before the interview, there's always a preparation meeting. That is an informal meeting where the interviewer meets with the police and Child Protection Service to prepare the interview. And the meeting is often on the same day or the day before the interview. And there, the police and Child Protection Service, they can give the interviewer thorough information and guidance on what the most important aspects of the case are and what needs to be addressed during the interview. And I also note that the interviewer or the Barnahus and the judge, they get access to all the documents of the case before the interview. But because the interview is only most often early in the process, sometimes there are not a lot of documents at that point. And during the interview, the judge and the interviewer can communicate, and the judge is in charge and can tell the interviewer to ask certain questions or address certain topics. And the police and lawyers, they can talk to the judge as the interview goes along. Here we can see certain guidelines that are used to evaluate what kinds of questions are realistic for children at certain ages. But guidelines are only guidelines, and every child is different. And like I said, the interviewers in Barnahus are specialized in working and communicating with children, so they aim to make each interview as successful as possible. The goal of this interview is to get the child's story in the best possible way. This counts as very important evidence in the case, and most of the time we have to look at it as the only opportunity to get this testimony, and we have to use it well. We have to try to maximize information and at the same time minimize the impact on the child. And like I said earlier, the main rule is that the child does not have to give another statement in the case, not at the police station and not at trial. What happens next in the case? Well, the police, they finish the investigation, gather all the evidence, and if the case is regarding sexual violence in Iceland, then the district prosecutor's office holds the prosecution authority, and they get the case and take a decision if they are going to press charges or not, if they're going to prosecute or not. However, if the case regards domestic or physical violence against children, then the police prosecutor holds the authority to prosecute, and then we make the decision, the police prosecutor. And if an indictment is issued, then a criminal case starts in the district court, and that child has then already given its testimony in court by law. And that is the interview I was talking about earlier. And more about that in the next presentation from Iceland. Thank you very much.
Labai ačiū.
Thank you very much for the assistant prosecutor, and we're continuing with the Icelandic experience by a judge from Reykjavik, Johannes Runar Johansson. Could you please tell us from the point of view of a judge the essence of this problem?
Good morning, and thank you for inviting me to this conference. I am a district court judge in Reykjavik, Iceland. I started as a prosecutor at the public prosecution service in Iceland, and then became an attorney at law and basically represented criminals or alleged criminals for many years, and then I became a judge later on in my career. So I will mainly focus on the process before court, but to start with, I would like to take you quickly back for some decades, because obviously we have come a long way in Iceland, and there have been some milestones on the way as well that have actually brought us to the place we are today. And you can see from this slide that there was increased focus on sexual offenses or violence in Iceland in the early 90s, and that's still the case. We have started focusing more on domestic abuse as well, in maybe from 2010 and onwards. And obviously this has led to some legal reforms in Iceland, quite important ones, and they have been focused on more or less on the victims as well, and improving the rights of the witnesses and so on and so forth. You can see we implemented an act in 1995 about compensation, so the Icelandic government actually pays compensation to victims of crimes, violent crimes, including children. And we have made some amendments to our criminal court procedure code, and some of them are quite recent. We basically improved or expanded the rights of the victims of crimes. But I would say there are actually three pillars to our child-friendly approach, and I would definitely regard our approach as child-friendly. The first pillar is legal representative to the child. It's the legal counsel, and the child is entitled to a legal counsel throughout the process of the case, and that is free of charge. I will come back to that in a minute. The second pillar centers on the one statement principle, which Daniel, my colleague from Iceland, discussed earlier, because a child will normally only need to give their statement once, and that is given in Barnahus, as he mentioned. But there are, however, some exceptions to that, and I will come to them in a minute as well. The third pillar relates to evidence assessment, because as Daniel said, the interview in Barnahus is quite early in the process, and there is no assigned judge to the case at that point in time. And the main rule in Iceland is that you have to bring the evidence to the judge that is presiding in the case in question. But there is an exemption in relation to children, that the judge is allowed to consider earlier statement, even though they were not given by or in front of him personally. But we will discuss this all in a minute. The first pillar is the legal counsel, and victims of sexual offences or domestic abuse, including children, they are entitled to legal counsel, as I said earlier, and that is from the early start of the case, where the legal counsel will be appointed by the police, and to the final judgment, where the legal counsel will be appointed by the courts. And this is free of charge for the victim and the child, and the cost associated with this representation is actually associated with the appointment, or associated with it is part of the overall cost of the case, and it will be borne, the cost will be borne by the accused if he is actually found guilty, or if not, it will be borne by the Icelandic government or the state if he is acquitted. And I think it's also worth mentioning that the this legal counsel has a duty of care to the child, but not to, for example, to its parents, even though they are obviously the legal guardians of the child. No, the role of the legal counsel of the child is to advocate on behalf of the child, to speak on behalf of the child, and to give advice to the child. And to protect the child as well. They are entitled to all documents of the case as they emerge. They can submit documents themselves, for example, in court directly, but not only through the prosecutor or the prosecuting authorities. They can furthermore pass on recommendations regarding the investigation if they want the police to do something or focus on something or if they are missing something, they can actually point that out to them. They can ask questions during trials in court. For example, in the initial court hearing in Barnahus, they can ask the judge to ask certain questions as well, and then the judge would formulate the questions and ask the psychologist that is actually conducting the hearing or the interview to ask these questions that they want the child to be asked about. And they can, moreover, they can all through the case, they can ask for court relief, for example, for the child as a victim of crime. They can ask for the court hearing to be held in private, for example, for the protection of the child. They can ask that the accused should be removed from the courtroom whilst the child gives statement in court, if it does, if that is the case, and so on and so forth. Now, then I come to the second pillar, the one statement principle, which applies mainly to younger children. When I mean younger children, or say younger children, I mean under the age of 15. And sometimes we actually ask children, even though they're only 14, to actually give a statement in court. But it's mainly younger children. But younger children, they normally don't need to repeat their statement, as we discussed. The statement given in Barnahus is the only one. And it is obviously given at an initial stage of an investigation. And in complicated investigations, there may be need to actually take a statement from the child later on as well. And this is a court hearing, as has been discussed. And if then a charges are brought before court, the prosecutor and the accused or his legal counsel can request that a witness who has given statement in court prior to charges being brought, that the witness will actually repeat its statement in court, and that includes children as well. But as I said before, if it's a young child, they would not be required to give a statement again in court. So the judge will just deny a request for such a statement. Yeah. So, however, if in the case that a child that is actually required to give a statement again in court directly, the judge has all the same means as he has in Barnahus. He can call in an expert to actually perform the interview itself. And he can remove the prosecutor, the accused, and the defense attorney from the room where the child is giving its statement, and so on and so forth. So the effect would thus be similar to what happens actually in Barnahus initially. And I, for example, I've actually had children of the age of 14 in my courtroom, and they gave a perfectly good statement. in a sexual crimes case. So it depends on the children as well. Some of them can actually give a very good statement in court, and that can actually improve the case as well. If the child is 15 or older, it's more likely that they would be required to come to court and give or repeat their statements as well. It is less rare that we would stick to this one principle rule, one statement principle rule, as I said. And if it is 15 years or older on the date of the trial, regardless of when the offense was actually committed, it's at the date of the trial that is important. And if someone would actually request a child, would give or repeat the statement before court, if it is older than 15, the threshold to actually deny that is higher. In this case, the prosecutor, the defense attorney, and the child's legal representative could all be present and ask the child questions directly. And the judge as well, of course. But as I said before, the hearings are most often held in private, so there would be no one else in the courtroom. In Iceland, we usually have one judge in each case, but in special circumstances, we can call in some expertise, and we might have a panel of judges. And as I said before, it is not always the case that a criminal case is allocated to the judge that actually was responsible for the interview in Barnahus, but we tried to do that. We tried to give the case to the judge that was actually handling the interview in Barnahus. But even though that's not the case, the judge is permitted to actually consider the statement given in Barnahus. And the interview from Barnahus is also replayed in the courtroom and during the trial. Evidence assessment is the third pillar I would like to mention. And according to the Icelandic legislation, it is the role of the judge in each case to assess the evidence, including the statement given by a child. And it's not in the hands of any other experts. The judge, for example, is responsible for evaluating the credibility of the witness statement, as well as the accused statement, with no expert opinions required. And for example, if we have expert witnesses in court, which are rarely, they would only be allowed if they were about the consequences of the alleged crime, not the credibility, because that is the role of the judge to actually assess the credibility of the witness and the statement given by the witness. The judge is required to take a holistic approach to the evidence and consider all evidence, including direct and indirect evidence. Obviously, the judge must consider all kinds of evidence. The statements are, of course, very important, but you sometimes have forensic evidence, you have social media interactions, evidence regarding usage of phones, etc., etc. And when the judge assesses the credibility of a witness statement and child statement, including, the judge must consider the child's age and maturity, the child's certainty, and the consistency of their answers, and the judge must also consider whether the child could or should realistically remember what the child claims to remember. So he or she must assess all those things. And based on all the evidence collectively on the aforementioned criteria, the judge writes a verdict. And it's all about the to actually assess whether the beyond reasonable doubt test has been met or not, and taking into account all the evidence. So in short, to summarize at the end, I think the main issues or things regarding Iceland is the spokesperson for the child, legal counsel, free of charge, and the child normally only needs to give one statement, in particular younger children, and the judge is allowed to consider earlier statements when he comes to his or her conclusion. Thank you.
Tai labai ačiū už tokią tikrai išsame.
Thank you very much for a very extensive presentation of Icelandic experience. We saw the entire process from the beginning of the investigation to the court decision beyond reasonable doubt. And now we would like to give or to hear the experience from Estonia. This is an expert, Merit Corbett, expert at the Children's Trauma Support Unit, Katja Polyakova and Karin Talviste, State Prosecutor of Estonian Prosecutor General's Office, and Katja Polyakova, Judge at the Karju County Court. Estonian representatives will present the Estonian situation.
Hello everyone.
Sveiki visi, džiaugiuosi būdama.
These have been really resourceful, and we are delighted to be here today with our colleagues and to share our Estonian experience with you. And I will start with Vanahus. A lot of things have been already said about the model, but so I will try to be concrete in my presentation and bring out the essential about Estonia. First of all, let's start with the Estonian map. And just to give you an idea of our Vanahus in Estonia, actually in Estonia, Vanahus was first of all the pilot project in 2017. And just a year after, in 2018, in January, it already became a public service of Social Insurance Board. And actually the same year, 2018, we already opened another Vanahus in the southern part of Estonia. In 2020, third Vanahus was opened in the eastern part of Estonia in Jõhvi. And the fourth one was opened at Pärnu city. It's the western part of Estonia. And you can see actually there's a bunny, which is our logo of our Vanahus, and there's a fifth bunny, which is on one of our islands. Actually, this is not a Vanahus, but it is a child-friendly pop-up room, which we also use for conducting child-friendly interviews. And here is just to give you an idea of the referrals to Vanahus. And I think it explains very well also the expanding of the Vanahuses in Estonia. And you can see the increase in the number of referrals. Here, actually referrals to Vanahus, which are not the criminal cases, but the referrals we were dealing with. And already when we started, so you can really see that the last year it was already 814 referrals. And another map, which is very important for us, we have been active partners of Vanahus Network when even before we became full members in 2022, we were already engaged in projects, and it has been really useful in many ways in gaining experiences and sharing experiences with our partners and learning from each other. And now to give you an idea of the system in Estonia, where the Barnahus is situated. In orange, you can see the state level, and in blue, the local level, and there's the Barnahus, the bunny logo in the middle. So, as I already mentioned, Barnahus in Estonia is a public service of social insurance board, which is a state agency under the Ministry of Social Affairs. And under the bunny, under the Barnahus, you can see there are the local level, the local governments. In Estonia, we very closely cooperate with child protection specialists at local governments. Our cooperation partners since the beginning of the service have been Police and Border Guard, Office of the Prosecutor General, and Estonian Forensic Science Institute, forensic doctors. And also here you can see the other important partners we cooperate with, so depending on the cases, but we cooperate, of course, with the hospitals, sexual assault centers, local child, as I already mentioned, local child protection services, and specialists from schools. Yes, very important, our target groups in Estonia. We are working in Estonia with the cases where the children have been sexually abused, or when there's cases of suspicion of sexual abuse, and also the children with harmful sexual behavior. It was the topic of yesterday's conference day. And also here you can see that the children who have been trafficked are in any ways, it's very important to bring it out because it's very difficult to detect, and we have had a couple of cases, and it's always very important to be aware of that. And we see that a lot of specialists, they don't have the necessary knowledge on how to detect these forms of possible trafficking. And just to mention about when I go back to these target groups, that at the moment we are preparing a research study in Estonia, which focuses on one hand on the efficiency of our service in Estonia, but also on expanding the target group. So there might be changes in the future as well. And now, yes, since 2022, our service, Barnahus service in Estonia is regulated by the law, by the Child Protection Act. And that it was really important and crucial in our work. And since then, now there's the obligation for the child protection officials to inform us when they have the information or the suspicion of the children who have been sexually abused, and also about the children who might have harmful sexual behavior. And this is in two ways, meaning that we also, at the Barnahus, we have to inform and involve the child protection specialist when we have this information, which might come from other sources to us. Because in Estonia, everybody can refer to Barnahus, also children themselves, specialists, and we work very closely with child helpline number, and a lot of cases also come via the child helpline. And of course, police cases, which come strictly from police. Here are the Barnahus quality standards. Also, you can find in Lithuanian, and in our, of course, we are operating in accordance with the standards and working constantly in improving our service. And as we know that the standards also evolve, and so it's we have been also involved in developing the standards. As part of the Barnahus network. It has been mentioned already, but it's always very important to bring it out that the very center of the Barnahus model at the Barnahus, what we every day do on a daily basis, are the rights of the child. You can read the usu last in Estonian, it means believe the child. This is our hashtag, and I think it's very important to bring it here again, that in everything that we do, we believe the child. So it's we never say that the child is lying, because there's always behind a need, the child in need in any ways, even if the story is not true. And so for us at Barnahus, it's very important to, together with our partners, to find the best solutions and to help the child. And of course, that everything that we are developing, we are taking into account that it is child-friendly and age-appropriate. For instance, the leaflets we have developed, And in all ways, actually, in all ways, the service is provided. And it's very important also to inform the children what will happen, who are the people who are talking to the child. And that's why this preparation is really essential way before the child comes to Banos physically. And here is another photo. It comes from one of our Banahus therapy rooms. And here is just to illustrate that also in decorating our rooms and creating the spaces for children, we take into account the views of the child and what the child considers important, because this is very important also for the whole process, also for the criminal process, and that the child is ready to disclose and everything, of course, including the people who are talking to children, but also we should never forget about the environment. And there's another thing I have brought out here on the slide, that we also ask the children about the therapists, because the child must have a negative experience beforehand, and so we find it very important to explain the need for the therapy and the different forms of therapy, and to find together the best solution possible. Here you can't see very well, but it's our workflow. And I'm not going so much into the details, but maybe bringing out the most important parts. Some of the parts I've already mentioned. The ups, you can see the laws, which are in regulating our service. Or I didn't mention before, but the therapy or psychological help in Estonia, it is covered by the government as well. So it is mentioned in the Victim Support Act, and the children have the possibility to have therapy until the age of 18, but of course when it's needed and assessed before us together with the therapists. And here again, maybe it's also important to mention that in Estonia, it's a bit different in different Banahouses, but the forensic interviews are conducted by police investigators who come to Banahus. But our Banahus specialists, we call them Banahus specialists, those people who work at Banahus, are also conducting pre-interviews and assessments, and also the counseling of parents and family members. And here you can also see that the different cooperation partners who work together on this slide, and you can see that there's in violet, you can see police-related specialists, forensic interview, forensic doctor, and also prosecutor, and the charge, but my colleagues will tell you more about their roles. And the last slide I have today is just to bring out the importance of the multidisciplinary and interagency cooperation, and that we all together know how to be in the best interest of the child at every step. As I already mentioned, that before even the child comes, the preparation is the key, and then during the Banahus service, it's important to decide together. We have to be together in that, and the trauma-informed environment and assessments as well. And also when the service ends, it's very important, the part. And here I would like to bring out, in Estonia, we have a joint data management system, which is called STAR, and we have it together with the child protection specialists at local level, so they have access to the system, and we have access at Banahus. So which really enables us to work with the families, with the cases. And child protection specialists, we consider them like case managers. And also for the follow-up, for instance, when the case is concluded in a way, is not actively involved at Banahus anymore, there's still the follow-up, which is done by the child protection specialists. And yes, there are a lot of important information, but maybe I would like to conclude with the importance of joint trainings. Over the years, we have seen really the results in being together, really physically being together, also online, but really physically being together. And recently we have had supervision with our prosecutors in one of our regions where it's quite problematic region for referrals, and we have seen it was really fruitful, and we will definitely continue with this format there. Thank you so much, Achu, and I pass on to my colleagues.
So, hello from me as well. I'm a state prosecutor from Estonia. I work in the internal control department. Today I'm going to tell you about the child-friendly approach in the prosecutor's office in Estonia, because since we came to the conference where there were like two topics, harmful sexual behavior and child-friendly justice, then I find that we have spoken too little about juvenile offenders themselves, although, as it was mentioned yesterday, they are a big part of this topic. So last but not least, my presentation is going to focus on the juvenile offenders mostly, so a few words about that as well. In Estonia, there has been a big reform started in 2018, and before that we were actually punishing quite severely even minor juvenile offenders. So we didn't have many non-judicial measures to use. We had community service and we had social programs, and we also had the possibility to refer the case to this juvenile commission that was located with the local municipality. It was basically a bunch of specialists sitting at a table, and the young person appeared in front of them and heard what he or she has done wrong, and then got some sort of obligations from them. So the prosecutor was actually quite distant from what happens to the juvenile offender after the criminal proceedings. And the young person's opinion was not taken into account really at all. So in 2016, what changed was that a new Child Protection Act entered into force in Estonia, and it shifted the mindset really, because it stated very clearly that the minor offender is in fact a child in need of assistance, and it really changed the way we see and how we treat juvenile offenders. So after that, we were also given, I would say politely, strong recommendation to change our punitive system towards minors, because they were serving real imprisonment before that period in Estonia. Also the directive came into force that referred the need to treat children according to their age and development and avoid punishment. So all three things combined led to the reform. So now what happened and changed after 2018 is the criminal responsibility age in Estonia is 14, so that you know what the age limit in Estonia is. But what changed, actually we changed all of our laws, the penal code, the code of criminal procedure, misdemeanor procedure, and a lot of, first of all, the obligation to consider the development and the age of the child when we are talking about the minor aged 14 to 18 was added to our law. So whenever we decide what to do with them, we have to consider that. Then also the emphasis to use rehabilitation methods and restorative justice over actual punishments. So punishments may be applied only if juvenile measures are not effective enough. So we have now a whole list of different obligations that the prosecutor or the judge can set on a minor offender, and if none of them have been effective, so we go basically by the list, like we use the least repressive methods first, and then we go up the list, and then real imprisonment is the very, very last measure to use. In Estonia, we now have, I think it's a handful, 7. Yeah, Katre says 7 children right now who are actually in prison. but it used to be, yeah, we had a 0 at some point, but we have had some very serious crimes lately committed by minors as well. And also, so now the role of the prosecutor has increased a lot because a lot of these cases get actually solved in the prosecutor's office. They don't get sent to court at all. So we have these opportunities. And also in 2018, the juvenile prosecutors gathered for a roundtable that has happened annually ever since. And we agreed on some very simple principles that we're going to follow in all the criminal proceedings in order for them to be more child-friendly. There's a simplified list here. The document is actually quite many pages long, and there are very specific rules of conduct in there. But basically, it is now, everything is revolving around the child. So we first of all need to find out what was the reason for this crime to ever happen. And then we see if we have any methods or obligations that we can set on them that would actually help them to remove these reasons to commit crimes. And we work together in a network with the child protection specialists, with the legal guardians, schools, barnahus, if it's that kind of case, etc. We encourage the child to take responsibility, so they also have the possibility to propose themselves how they can somehow like heastama. No, heastama kahju nagu. I lost the word, but anyway, how they can make the wrong right, or something like this, to put it in a simplified manner. So this is a list of methods that we can use, or list of obligations we can use by the prosecutor. So we can decide that they have to go to mediation, or they have to go to a social program, etc. There is a list, and our favorite, of course, is this point 6, any other relevant obligation. So because this actually gives us a possibility to ask them to do whatever and really take into consideration their own opinion, and also the opinion of the victim, of course. So I'll give you a few examples of what these other relevant obligations have been. For example, I had a whole class, basically, or maybe not all, but there were some people missing, but who were distributing CSAM materials, because they just thought that videos of naked kids were really funny, and they didn't really consider it a crime. They didn't know that it was considered a crime. And I had basically criminal files like piling up my table, and what to do with the whole class, like distributing these materials. So what we ended up doing, of course, after a lot of explanation, was that they did this presentation in their school about what materials these are, how they can harm children, even if we don't know the children in these videos, and what the effect and these consequences might be. So this was the way that we solved that case, for example. There's no need to send them to court or to punish them, and this was far more effective. So these are the types of obligations that we can use to really make a change there. And also there is a similar paragraph in our penal code. So if we do decide to take the case to court, then also the judge can apply similar obligations. There is a list that is quite similar actually to ours, but just with some additions. And there is also this point 10, any other obligation voluntarily assumed by the relevant person. So there is the same kind of freedom for judges, basically. Let's see. Oh, this is for misdemeanors. And now about the specialization. We are very strong in specialization in Estonia in the police and the prosecutor's office. And also we have specialization in courts, cases involving minors, both victims and offenders, is one of the areas that all courts have to have specialized judges at. And we have brought one with us, so Katre will have the opportunity to speak right after me. We have specialist prosecutors to work with minors, and starting 2020, we also have specialized consultants to work with the prosecutors. So they are actually now responsible for all the cooperation between the local governments, the child protection services, and also to find those very special obligations or services that would fit the need of the child. So they are a great help for the prosecutors. So they do this social work basically, and they make their own recommendations to the prosecutor what these obligations might be. And since 2024, we also have these specialized consultants working with young adults. So we have actually the opportunity to use the same obligations that were listed before with young adults up to 21 years old. So if their development and their mental state is considered to be such that we should consider them as minors. Because as we all know, nothing happens overnight. If a person becomes 18 years old, it doesn't mean that their brain is now somehow so differently and fully developed that they should be treated like a 50-year-old. So this is also another great opportunity that we have. And what the impact of the reform has been. We have developed a really specialized juvenile justice approach. We have minimized, I think, the best we can, the negative effects of criminal proceedings, both for the victims, for the witnesses, and also for the juvenile offenders. Because I find really strongly that the justice system can never be truly child-friendly if the child-friendliness is only considered towards victims and witnesses. We also have to be child-friendly towards the juvenile offenders. Like I said, a lot of these juvenile criminal cases get resolved during pre-trial proceedings in the prosecutor's office. It's about 75%. So Katre hardly ever sees my juvenile offenders, but some still find their way to the judge as well. And our criminal proceedings for minors are faster. It has been also stated as a goal that no juvenile offender should be processed longer than 3 months, and they are more flexible and age appropriate. And the juvenile cases are one of the priorities, both for the police and the prosecution. And we also see encouraging statistics regarding juvenile offenses. And this is what I'd like to end with. So at the time when we see that the blue line on top of the chart is actually the number of 10 to 17-year-olds in Estonia, which has increased over the years. But at the same time, the number of offenses committed by juveniles has decreased. So this is the picture that we want to continue seeing, and why we actually really believe that these changes have been effective, and they give us results that we'd like to see. Yeah, I can leave it on the screen, and now I will give the floor to our judge, Katre.
Hello from me. I haven't prepared a presentation because I'm, as you heard, a mascot. I would like to start my words with a thank you note to the organizers of this beautiful event. It has been very interesting 2 days, 1.5 at the moment, but we are moving towards the end of the event, and I would like to thank the organizers for inviting us and all the speakers. It has been a pleasure to hear other countries' presentations and practices. Thank you to the Nordic countries for being our mentors for every sphere of development for years. Thank you our Latvian and Lithuanian colleagues for bearing with us all those years, for being our Baltic brothers in better in birth, and for all the jokes about Estonian slowness. You are all forgiven. This is a pardon from judge. But few words about child-friendly justice from the point of view of a first instant court judge. I have been a judge for almost 30 years, so I'm feeling entitled to say those comments that I'm going to say about judges. Please do, if there is a Lithuanian or Latvian judges here, please do not take personally. It's my personal opinion as a judge. As you know, the courts and judges in particular are very important and independent branch of procedural circle in every case, especially in criminal cases, and judges are clearly a proud and independent people, and thinking that we know it all. We are specialists in every field of law, every case, whether it's common theft or traffic violation or murder, or as we are talking today and yesterday, child-friendly justice. But as you heard from Karin, since 2021, by the Courts Act, it's made mandatory for Estonian first instant court judges to be specialized in juvenile cases, both in civil and in criminal cases. And the only other sphere of law in which the specialization is mandatory is insolvency law, only minors and insolvency. And you might ask why minors? The idea is the judges can, in first instant court, they can specialize in many areas. For example, some criminal judges are specialized in economic crimes. We can choose our specialization from the field of law that we feel stronger, that we are, for example, if a judge has been working prior to becoming a judge in another sphere, he or she can use his knowledge in certain sphere. But the legal reasoning about making mandatory to specialize for judges in juvenile cases was the idea that the client, the children, are such a delicate material that person who works even if in court with children cases must have special training, special education, and special knowledge about child's psychology, how to question a children, and every person is not willing and is not ready to do this job. This has to be people who want to do this job and who are willing to learn more in order to speak the same language with the children, and in order to speak the same language with the specialists who are specializing from the first days of the case in their root area. So, a few words about our experience. Harju District Court is a first instant court covering Tallinn, capital area, and the surrounding areas, and it is covering almost half of the population of Estonia. More than 600,000 people are living in our court area. And we have 4 specialized judges. We do not have a lot to do with juvenile offenders because, as you can see from the 2012 from 27,000 cases of misdemeanor and crimes committed by juveniles in Estonia, it has decreased to less than 4,000 offenses per year on 2024, which means that we do not have lots of cases with juvenile offenders in court because prosecutors and police do all the work. I started 29 years ago, and every given day I had on my desk 250 criminal cases where the offenders were juveniles, and last year, full year 2024, altogether in Harju County Court, Harju District Court, there were 10 criminal cases coming all through the year coming to the court with juvenile offenders, 10 criminal cases only to 4 judges. So we are using our knowledge and our training as a specialized judge to preside also over a case where there is a juvenile child as a victim of crime, child as a witness of a crime, and also vulnerable victims in cases of domestic violence. So this is the cases that are allocated to us, and even with all those 4 areas, we are not getting as much cases as other criminal charges, so there can be another criminal cases also allocated to us in order to get the same amount of workload as all the other charges in our court. And if you would like to ask questions about my specialization, there's after the lunch there is a round table. That's my short presentation, and I'm open to questions. Thank you. Thank you.
Labai ačiū pranešėjai.
Thank you very much for your presentation. Thank you very much for your presentation, and I thank the judge for this simple and clearly cut view and approach to your work. And I would like to announce that presentations were really very good. You kept the schedule, and we still have some time before lunch, and we can use this time for our extra questions, because some colleagues had already left our conference, but we still have colleagues from Denmark, Norway, and Estonia. So if you have any extra questions, you can ask them now. And if not, you're welcome to join us during the roundtable discussion at 2:45. Do we have any extra questions you would really wish to ask? Well, actually, the flights are pending, so Riminas Valantukevičius from the prosecutor's office. I wanted to ask Estonian colleague Karen. In your presentation, you said that 75% of juvenile cases are being prosecuted in the pretrial phase. Are the pretrial investigations being terminated? What are the procedures that you take for those cases not to reach the court?
They are not... I will hear myself like this. So they are not terminated as in a way that there is no criminal case. But in Estonia, the prosecutor has the right to set these obligations that I showed on the slide as well. So we can basically make our decision, which is, I would say it is kind of equal to a court's decision in a way that it is compulsory to follow. And if the juvenile does not follow and does not complete these obligations that are set to them, we can renew the case. So this is, and we have the same opportunity with adult offenders as well. So this is just opportunity we can offer them to resolve the case without the court's involvement. So, and also these obligations and this history will not be shown on the Criminal records. Yeah, exactly. So, we won't like stamp them for their future. So it was something that happened. Has been resolved. Of course, the prosecutor's office and the police also later in the future we see if there has been any history, but we won't like mark them for life. Yeah.
Gal dar kažkas, ačiū už atsakymą ir klausimą, gal dar.
Thank you for your answer. Any more questions? If you need to ask a question, please use the microphone.
Kol kas nematau.
I see no questions. I believe that we're all trying to process the information we've heard. And I believe that during the lunch break and after the lunch break, which ends at 2:45, we will be able to have many questions and answers. Even if we don't have many answers, the discussion will still be effective because the goal is to ask questions and to raise issues. So enjoy your lunch.
Oh, the last time we were here.
Labai smagu, kad susirinkome.
I'm glad to see you all here because we were wondering if people would come back after a 1 hour break only for a discussion, but you're here and we're glad to see you here. And of course, the topic is very important, and not only the presentations are important, it's important to discuss about this topic. And coming back to the previous part, if you have any questions, please raise your hands. We have fewer of our foreign guests due to balloons or weather conditions. We're glad that we have colleagues from Iceland and colleagues from Latvia. So if you have any questions, the floor is yours. Prosecutor Lina Zakrauskaitė would like to ask the representative from Iceland. In the presentation, we saw who is included into the interview of a child. Is a suspect given the right to participate in a child's interview, or just the defender of the suspect?
Yeah, the suspect does not get to be involved in the interview. However, there is always a lawyer on his behalf, a defense lawyer, who is attending and has the rights to protect the interest of the suspect. And like I said in the presentation, the main rule is that we try, the police and the Child Protection Service, they try to not inform the suspect about the interview beforehand. So in many cases, a lawyer is called to be in attendance, but he does not necessarily know who the suspect is at the time, just when he shows up. So they are not talking beforehand. So most of the time it's like that.
Thank you.
Hi, I'll continue with the same topic because I also have some questions to my colleague from Iceland. I noticed also the defense lawyer's presence, which is very welcome, but I was wondering in what phase of the criminal proceedings then the interrogation of the child happens, because in Estonia it's pretty much usually the first thing we do, and we often don't even know who the suspect is, but or do you have the ability to point the defense lawyer so that you don't actually even have the suspect yet? So what happens if you don't know who the suspect is?
Yes, that's right. Also in Iceland, this interview most often happens very early in the investigation. And if we don't know who the suspect is at the time, there's always a lawyer present, and he is then the lawyer of the unknown suspect at the time. So it's to guard the rights of the suspect, even if we don't know who he is at the time.
I have several questions for the representatives from Iceland. I understood that there are no forensic assessments and that judges make decisions on how to assess the reliability of evidence. So my question is that in Lithuania, children are interviewed for many times, and the same questions are given for a child in order to show that the narrative is the same and consistent. And if there's just one interview, how do defense lawyers behave? Because they try to undermine the child?
Thank you for the question. I think in Iceland we certainly have forensic evidence, and that is obtained at the initial stage of the investigation, and that is also brought before the court when charges are brought. But as regards the interview, if it is a young child, we try not to take a statement except in the beginning. Obviously, there can be developments in the investigation, and there can new information, for example, that actually requires us to take or the police, because it is in the hands of the police at the time. But as my colleague said, you have an attorney at law present when the statement is taken in the beginning, and if the defense attorney later on, after charges have been brought, wants to take another statement, he would have to put forward a request for that, and that would be for the judge to consider whether to actually accept it or not. And for example, if it is a young child, the judge would be very reluctant to accept the request. If, however, it is an older child, let's say 14 years of age, that would maybe be a different case. It would be just considered and decided on. And I think a 14 years old child can give a very, very strong evidence in court as well. And in my experience, you can see a statement actually developing as well, because you take a statement in the beginning of a case, everything is quite strict, and the child is reluctant to speak, it's all new to the child, so it's quite hesitant. But as the investigation and criminal proceedings proceed, it can be a different story later on, so it can be actually good for the case to take a statement later on, if we think it's good for the child. So, and that is where the legal counsel of the child comes into play as well, because it is for him or her to actually assess, is the child ready to give a statement in court? Does it want to give a statement in court, etc. And if the child gives a statement in court, the defense attorney is present and can ask questions. So, but young children, we would probably not allow that.
Prosecutor, well, I would like to thank all the foreign guests for not being afraid and coming to Lithuania with your very practical and precise and interesting presentations. Unfortunately, our Christmas tree will be lit on Saturday, so you will not be able to see it. As a person working in practice as a prosecutor, my question is, what is happening at the interviews with children with special needs and inborn special needs? What happens during the interviews of such children? Who is the participant at that interview? And how is the reliability or trustworthiness of such children with special needs is being evaluated or assessed by court if children have special needs which are inborn?
Is that for us as well? So,
yes.
So thank you, and you're most welcome. It's a pleasure to be with you here with you today, and who knows? I think we have a weather warning, so we might be here on Saturday as well. So who knows? But coming back to your question, I think it's as we all know who have participated in hearings or court hearings. It is always difficult and sensitive to actually take a statement from disabled people, and it can be tricky. And in Iceland, we would we would call in an expert in that area to actually conduct or perform the interview. And if such a person would have to give a statement in court, we would probably call in an expert and have that part of a panel of judges. So we would bring in the expertise to actually deal with that. And yeah, there would probably be 3 judges in that case.
Estia.
Well,
What about Estonia?
I don't have actually anything to add because this is the exact same way. Only in Estonia it doesn't depend on the number of judges does not depend on whether it's a complicated case like this or not, but it depends on the paragraph of the indictment.
Galbūt įsiliedama į šitą diskusiją.
Well, to join the discussion, since the guests presented their practical models that exist in their countries, what is the practice in Lithuania from the procedural point when we speak about young children or underage children? Because children victims are categorized into young children and teenagers from the age of 14 to 18, and young children up to the age of 14. So in the pre-trial phase, during the pre-trial investigation, in cases where we have sexual offenses against children, the practice is that the interview of such a victim is conducted at the judge of the pretrial investigation. And this model guarantees, well, we have a specific proof of evidence. Proof of evidence is made only in court. Only court can accept that some evidence or some information can be confirmed as evidence. And during the pre-trial investigation, we're trying to interview children in order to prevent the traumatization of children. And then we have a specific regulation that this data collected during the interview with the pre-trial judge, this can be used in court. And in all the countries and the jurisprudence of the European Court of Human Rights stipulates that 2 things have to be adjusted: the right of a suspect or a defendant and the interest of a child. And suddenly we do have cases which are in line with the case law of the European Court of Human Rights, when the suspect has never had any opportunity to ask questions to a child victim. We are not asking about direct questioning, but through the judge, for example, because the suspect or defendant is not allowed to participate in interviews due to negative influence. So the child's interests are, first of all, put as priority. And the court says, according to the practice of the Constitutional Court, that the court takes the final decisions and evaluates the evidence in its entirety. And the judge in the case Well, we don't have the model such as in Iceland, when a defense can be established for an unknown suspect. Well, it is an interesting practice. Don't you face the dilemma that a defendant complains because he or she had no opportunity to consult with his representative beforehand? What about this aspect? How do courts interpret this? Are there any complaints on the lack of possibility for the suspect or defendant to consult with his or her defendant during child's interview? Because according to the Lithuanian model, we have the possibility of complaint on the part of a defendant. Certainly this depends on a national model. Do you have any remarks on that? Could you answer to my insight? Well, I just wanted to introduce my practice, and I also invite other colleagues to share their experience in this field. No, I guess. Hello, prosecutor. I wanted to ask foreign guests. Today's topic is about children as victims, but we also have suspects who are underage. Are similar methods of interviewing applied for suspects who are underage, or differences exist here? For example, when suspects are underage and they are being interviewed.
Yes. In Iceland, the minimum age to be held accountable in a criminal case is 15 years old. So we mainly are talking about then like 15 to 17 years of age regarding suspects. And since they are already 15 years of age, most of the time statements are given in a police station. But maybe, I don't know if Judge Johannes has something to add.
Yeah, I think in Iceland maybe the youngest suspects that actually have come to court are maybe 17, 16 perhaps, but 17 definitely, and they will just give the statement in court, not in any other types of place like Barnahus or something. So they would be asked to give a statement in court. But coming back to your question on comments as well, and I can really relate to that. That a defense attorney could actually complain that he has not had the opportunity to actually ask questions, and I actually have been in that situation myself, not as a judge but as a defense attorney, and actually I raised that issue, and that actually led to my client being acquitted. So I know this can be a real issue in some instances or some cases, but this has rarely been raised in Iceland in courts, at least not in my experience. But I can certainly see the issue being of concern. But I think what I would do personally I would actually listen to the defense attorney. What is wrong with his statement given in Barnahus? What do you want to ask in addition to what has already been asked? And if the questions were actually valid or the request was valid, I would consider to repeat the interview or add to it or have a second interview so he could raise these questions. But I would always protect the child. And I would, as I said before, we have the same means to actually perform or conduct a hearing before the court, basically removing or ask the prosecutor and all the rest of them to leave the room, for example, or even have it in Barnahus. So we can repeat the statement or add to it if there is something that needs to be asked, but it needs to be a valid reason, not just to you would never exclude it, you would always consider it, and if it is not valid or deemed not valid, if it is just to harass the child or someone, that's not something I would allow.
I would like to second the prosecutor. I would like to add to this question. Prosecutor asked question about minors, and she spoke about persons who are not liable for criminal laws. Are there any protective measures in criminal proceedings in the interview of such persons?
I mean, young people under the criminal liability age. Okay. Well, we don't. In case that we determine that the suspect is actually under the criminal liability age, the police conducts a conversation with them, but they are not interrogated as they cannot be prosecuted for their actions. So we do get like an explanation from them and then refer them to child protection services.
Yeah, I would just like to add it's very similar in Iceland to what it described from Estonia.
Valstybės vaiko teisių apsaugos ir įvaikinimo tarnybos direktoriaus pavaduotoja Lina Jakavonienė, aš norėčiau užduoti.
Children's Rights Protection Service, my question goes to Lithuanian and foreign experts. By continuing the remarks by Zanchkauskienė on national regulation, when children are interviewed at the pre-investigation judge, do foreign countries have such a practice when children go to court, to a special child-friendly room, and be interviewed by a judge in the pretrial phase in the court? And the question goes to our institutions about whether you think that such place for a child, I mean the court, is the best place to be interviewed, or maybe we should look for some alternative places. Is it a set practice, or this is due to the comfort of adult people? But is it really necessary to make an interview of a child in the courthouse? Is it a proper, suitable place for a child?
If I start from Icelandic perspective, if it is a criminal case, we would always have the interview in Barnahus. If it, however, is a civil case, we would sometimes meet children, and we usually meet them outside of a courtroom in a special room, either in the courthouse or elsewhere. So, for example, if it is a custody case or a child protection case, then we meet the children elsewhere. Not we can even go to children where they live or whatever. So But that's then an informal interview by a judge. It's not a formal one. But we certainly don't expect young children to come into a courtroom.
And from Estonia's point of view, the practice is similar. In civil cases, the charge goes to the child wherever it's suitable, either to the house or to the school or somewhere to the kindergarten. We also have, every courthouse has the child-friendly rooms, which are not courtrooms. It's, for example, in our court, it's on the first floor, near to the wardrobes, so they can come to the courthouse, but enter to this room directly without going through the courthouse. And the judge has prepared the questioning, and we have, in criminal sphere, all four of us have been trained to question the children. In criminal proceedings, if there is a need to ask additional questions, for example, I had a case of sexual assault of a 9-year-old girl. The interview was conducted by the police officers, and it was videotape, and it was quite good interview. But the defendant, during the court proceeding and at the end of the pre-trial proceedings, the defense lawyer, who was then active, had right to ask questions, and there were additional short video answering to questions. But in court phase, there was a new defense lawyer and new tactic for defense, which they needed additional questions to the child, and then in court proceedings, the child came to the courthouse. I, as a judge, was with prepared questions with the child in this special room, and the other parties were in the courtroom seeing us discuss and answer the questions through the video conference. The voice of the video system in the courtroom was put on mute, so they could not call, they could not say anything. They saw and heard what we were speaking, but they did not have a chance to ask questions and to mess up with the child's mind or something like that, to shout or something. So it's possible, yes, in different cases for a judge to deal with a child directly in courthouse or in somewhere suitable for the child.
O kas norėtų iš lietuviškos pusės atsakyti?
Maybe the Lithuanian side.
Ačiū.
Sveiki, Auksė, prokurorė.
Thank you, Auksė, prosecutor. Well, this is due to our legal regulation. The moderators have mentioned the court decides what can be considered evidence in court, and this evidence had been collected in the pretrial investigation. And the child is being interviewed at the pretrial judge, and we take the child to the pretrial judge. And at least we have great interview rooms in courts in Lithuania. Certainly, if we had the special centers around Lithuania, we would be very happy to bring children to such specialized children throughout or across the territory of Lithuania. If, for example, a victim lives in Vilnius, in the capital city, or in Klaipėda, for example, and we have a specialized center in Vilnius, so taking a 5-year-old child to another city would be very tiring. So we would bring these children to the court, and that would be a short distance. The problem is that we have a lack of such centers. Luckily, We have child-friendly rooms in courts, and they're in line with the top requirements for children. The child has no contact with the courtroom. The child doesn't see the participants of the case and can communicate with the psychologist and with the judge via the teleconferencing means. So I believe that this is the best solution that we have so far in Lithuania.
I just want to add an example. In Tartu, where I am from in Estonia, the courthouse was recently renovated. And although it also has a freshly renovated children's room, then it also has a courtroom where the table is round. So it's not a classical courtroom where there is a judge and then opposite sides, but a round table where everybody can sit around. So it's especially good, I think, for mainly for civil cases, of course, where there is a hope for compromise, like all these child custody battles, etc. But also, what I have found is that before our police stations had these children's rooms, etc., so a lot can be done also with just these simple settings. How we sit, we don't like confront the child, you know, how we talk with them, how we dress, how like formal we are. So there are also like a lot of very simple things that we can do, and we are already closer, and also that we don't like stand with a small child, etc. So there are a lot of these really easy things to do that we can do anywhere, wherever we are. It doesn't. We don't need all these fancy environments all the time. So it's just the little things that matter to children.
Tai prašoma.
Klausimas gal šiek tiek nelabai.
The question is related to the topic. It's very important for us working in courts. During an interview of a child who is a victim of any crime, and when there's the suspicion that the perpetrators were from his family, how do you solve the case of the right of not giving a statement against his or her own family? Because very often the child is a source of data. So how do you explain to a child his right to refuse to give statement against his or her own family, and if a child knows the interview is stopped?
I can start. Estonia is one of the countries where we do have to explain this right to every child that we interrogate, no matter the age. So it is done as child, like, as child-friendly way as it's possible. And basically what our investigators say is that now we are going to talk about things that that have something to do with your family. Do you know who your family is? And then they talk about who they live with and like who this close relationship around is, around the child. And then they just say that if you don't want to talk about them, you don't need to. But there was a discussion. They used to say that if you don't want to tell anything bad about them, but this is already like this negative. Well, anyway, it sets this negative tone. So basically, and the right to refrain from giving statement. It doesn't matter if you want to say anything good or bad. You just don't have to. So that's the same way that it's explained to the children. And of course, if they say that they don't want to, then this is it. And this is we have to see if we can continue with the case without the statement of the child or not. So it's just as simple as that.
And it is exactly the same in Iceland as well.
Aš dar pasinaudoti noriu progą.
I would like to take the opportunity and to ask our Estonian colleague, well, your presentation was very interesting about underage suspects, and you have individual assessment of suspects. And this actually resulted from the transposition of the European directive. So what is the model of individual assessment of suspects during the pretrial investigation? In Lithuania, for example, individual assessment of suspects is regulated by law as collection of information about the child, information on the family, on educational performance, on the background, documents and papers, and presentation of that to the prosecutor's office. How do you conduct the individual assessment of a suspect? Is it in any way special in Estonia?
I was waiting for the translation. Can I just first ask you, who makes this report in Lithuania? Is it the probation officer or somebody else?
Vaiko teisų.
Well, in Lithuania, it's a Children's Rights Protection Service, but if a child is detained in an exceptional case, then the assessment is made by the Child Protection Service and the probation officer. But actually, the Child Protection Service has this duty to collect all this data and background on the child, including the family, educational performance, and the environment of the child. But this is basically the collection of necessary documents on the child and presentation of such documents to the prosecutor. I will clarify that we have three institutions here. If a child is not detained, then the Child's Rights Protection and Adoption Service does it. So 25 working days are given for that. And also information on the special needs of a child are provided. If a child is detained during the pretrial investigation, then the assessment is given by the institution that holds the child. And we also have a social assessment, which is conducted by the probation office when the child is being convicted. So we have a variety of such institutions responsible for assessment. So if individual assessment is conducted in your country, what institutions conduct that assessment? Is the assessment evidence-based or science-based? Because the directive provides for a multidisciplinary or holistic assessment. What institutions are responsible for providing this assessment in your countries?
Is that in Estonian criminal procedure law, it says that we are obligated, if we want to prosecute a case against a minor, we are obligated to order the probation services to make this report, like a pre-trial report. And there is a special law that states what has to be in this report. But I have to be honest, often what happens is that actually during the criminal investigation we already have most of this information gathered, because we always do ask the child protection services, we contact the school, we gather the health data or like any kind of data that we find useful. So a lot of times what we have discovered, and this is quite recent now, is that we don't actually ask the probation officer to do the full report, but we are now piloting it so that if we find that there is an area that we don't know so much about, then we ask them to go and like find out about this, this, and this. They can make house visits. They can also like talk to people, gather documents, whatever they need to do it. but there's no point in making them do like double work if we already have this information in the proceedings. And if we don't plan to go to court with the case, as I mentioned, a lot of these cases get resolved in the prosecutor's office, then these our special consultants that I mentioned are actually the ones doing this information gathering. So if needed, they gather together network of specialists who have been in contact with the child before, and they do all this like asking data from here, there, and any other places that are necessary. So they gather this information and they bring it to the prosecutor. So if we don't go to court, we don't necessarily follow this very strict path that is set for the cases that go to court. So it's different. It might be different.
Aš turėčiau tokį diskusinį klausimą.
I have a question for discussion coming back to forensic assessment, and I will start from afar. I've read a scientific research where two sexual crimes were compared, molesting and rape. And if there are two criminal activities, similar ones, against a child or an adult, it is more likely that the activity conducted against a minor is less punished than the one conducted against an adult. And there's a common attitude that minors should be protected, especially in the criminal proceedings, but we have situations where punishments for crimes against children are not so serious. And sometimes we presume that children, when they testify, they might lie. And if adults, when they say that they have experienced sexual assault, whether they do have to go through so many steps during the process, is their statement assessed as reliable? And this is more of a question for our Lithuanian colleagues. Is there some kind of disproportion here?
Aš galbūt papildant ir provokuojant diskusiją.
I would like to add to the discussion, yes, it is the case, and our foreign experts spoke about that we need to believe in a child, and international community talks about seeing children's words as truth unless proven otherwise. In our country, the situation is vice versa. We start believing a child when experts confirm that a child does not is not a liar and does not fantasize, and that we have data to prove that. So to add to what Agne said, sometimes foreign experts don't even understand our issue. So I wanted to ask whether it's our need of our case law to prove that a child does not have a tendency to lie, or do experts from foreign countries also encounter similar situations, and how do you solve those situations? Or is it prevalent in other countries where you need to provide evidence for the court that the child's testimony is true and their statement is reliable? So I think, Agne, we're talking about the same thing, and maybe we expect more evidence from a child than we would expect from a victim who's adult.
Kadangi mes prokurorės praktikės, tai pasidalinsim abidvi.
Since we're both prosecutors, we'll share our experiences. I work in the Court of Appeals of Lithuania and the Supreme Court of Lithuania, and we deal with very difficult crimes serious crimes committed against children. And I can tell you honestly, courts do not have special requirements for children's statement. We don't ask to tell them the hour of the crime. A child can confuse even the years. He can not be sure even about the place of a crime, and we don't have these requirements in courts. And we evaluate the situation differently when it comes to crimes against children. I'd like to add to that, because our case law requires the confirmation of forensic assessment, but cases are different, and the forensic assessment is required when we lack other data to confirm certain things, and or if the circumstances are controversial, and our case law is changing regarding forensic assessments. We talk about psychological assessments whose conclusions are possible, and they are not necessarily can be dismissed. So we have to talk about the entirety of data, and we base our work on that. But we have to talk and think about the importance of a child avoiding being interviewed several times, because we see good practice from foreign countries that forensic assessment is being carried out watching the video of an interviewed, reading the document, and a child is not repeatedly interviewed. So this foreign practice is very valuable and can be considered a good practice that can be used here in Lithuanian courts. So we finally reached the point that I've been waiting for. I say how we see the situation. As an ombudsperson, we always see very bad cases because we don't deal with good cases because people don't come with them. So our bad cases are when there are incidents in domestic environment, in the family, and sometimes a child is removed from the family and the child needs assessment, and the court orders the assessment, and it's the discretion of a judge to decide on whether the assessment is needed or not. I do have a law diploma. I would be glad to have psychiatrists and psychologists to assess that. The problem is that forensic assessments are ordered very often. The number of them is high, and the only solutions offered by our decision makers is to allocate more funds to forensic assessments to cover them, because the queues formed for 8 months, even for basic cases of violence. There's a report in January. Children are removed from the family. In March, the judge orders the assessment, and the assessment is carried out in December, and the child comes back to the family 1 year later. And the question is very difficult, but the number of assessments is extremely high, and our center of assessment cannot deliver. Another important thing is the method of the assessment, and when we looked at the Criminal Code of Proceedings, there is an opportunity to interview a child one more time. We don't treat the meetings related to the assessment with a child as additional interviews. So the child has to repeat and tell their story many times, and we have to ask our colleagues the same question, and we hear our Norwegian colleagues talking about that. Yes, experts are needed, and they need to participate in the primary interview, and also experts can revisit a video and the documents. Is a child really in need to repeat the interview 8 months later? So this is a nuance that's very important and that we have to address.
Well, our tradition in the criminal proceedings is related to additional carefulness, and the prosecutor seems to be afraid to be biased, and this is a type of an insurance. Therefore, the expert is asked to carry out a forensic assessment in order to substantiate the objectivity, and the judge, while hearing the court and deciding on the guilt of a person, also wants to remain objective and seeks to obtain the feeling of justice. And this is, at the end of the day, extends the process, and the terms of the assessments are being postponed, and actually it delays the process, and in the end the decision is taken finally, and the only solution, well, actually, luckily, we see no acquittals in sexual assault cases against children. So maybe the end result is still positive despite all those disadvantages. Well, I would like to explain this fair. We have the decision of the European Court of Human Rights, where an assessment had to be carried out by the prosecutor, and this is what the European Court of Human Rights ruled. Hello, I'm Dr. Laudonita. I represent the Forensic Psychiatric Office. I thank all the speakers for their presentations. Unfortunately, yesterday I could not attend. I feel that it is very difficult to listen to all of that when I hear foreign colleagues and sharing their experience. We can really see the advantages of those systems. Our system is different, unfortunately. We have the office responsible for conducting forensic assessments, and we were continually speaking about interviews, and at some point we were lost in the idea what interviews and assessments are. Well, this is not the same. Before that, I was an interviewer, and now I'm an assessor, and I know that these two tasks are different. If we have children's interviews, please correct me if I'm wrong, but the goal of the interview is to collect all the information. And I've heard this message from the prosecutor's service that concrete facts are not that important, that the feelings are important. And sometimes the facts are being erased in children's minds. Therefore, the aim is to collect all the information in the initial stage. But the goal of a forensic assessment is quite different in my understanding. And from my practical experience, I have examples when children don't speak during the assessment because they have strong emotional reactions or they are reserved and they refuse to speak during the assessments. Therefore, we analyze verbatim reports, we analyze videos of interviews. And my task is not to interview once again and to assess whether the child can testify in court or whether the child can act as a witness. And this also is related to children with disabilities. And in these cases as well, we assess not the message, not the narrative of a child, not the story of a child, but whether the child can testify in court. And it is important in our legal system to evaluate the level of harm done to a child's health. And this is not the area that I'm competent in. And I think that we should not actually confuse interviews with forensic assessments. We have received feedback on many occasions what happens during the assessments. We interview children, for example, 8 or 9 months later, and we manage to collect many more facts than the facts were collected during the interviews. So we have to think of improving the quality of interviews. And if we improve the quality of interviews, then forensic assessments would not be needed. And I hear your messages and your concerns, but if we had 8 people responsible for Lithuanian roads, what the speed of road repair would be? Well, we deal with our own problems. They're very painful to us. But let us improve the part of interviews. Children are brought to our office by suspects. And when we speak with a child, we see that violence continues. And then we refer to the child's protection services. I think that interviews, an interview part should be strengthened and enhanced. And this would help the work of forensic assessment.
I have a short remark. We often offer assessments because there's a harm for a child's psychological health, and we cannot assess the scope of this harm to their health without experts, especially in case of very serious crimes, and we need a forensic assessment in these cases, and there's a demand for experts because reactions to very strong stress are determined only by experts.
Gal dar norėtų kolegos iš Estijos?
Maybe the colleagues from Iceland or Estonia would like to add something to this topic.
I can start maybe. I think our view definitely that it is important to take a statement from the child early at the initial stage of the investigation, and it is also very important to basically interact at that time. Maybe remove if it is a domestic abuse case, you have to remove the child from its home and put it in a safe environment, obviously. But as I said earlier, if the investigation then involves, there might be a need to actually see the child again and have another statement. And it's quite common that you have a statement. As I said earlier, the child is hesitant, it's reluctant to give a statement. Everything is new, everything is of scare. And the child is quite scared as well. So, and you have to build a secure environment for the child to actually speak. But definitely you need to take a statement as early as possible. And that is, our model is based on that, obviously. But as regards expert opinions, I agree with that. It's a very essential document in a case involving a child as a victim to have an expert or an adult as well. It's not just child. It's all cases, for example, regarding sexual offense or something, or domestic abuse. You need to have expert opinions on the consequences of the alleged crime for the victim, and how the victim has then developed over time, because we have a case that actually starts today. It's in court next year or the year after that. So it's very important to see how the victim actually reacts to expert the aftermath of the crime. So it can be essential, but only as one of the documents that we assess.
To begin from the beginning of this discussion, in my personal opinion, children do not lie more than the adult do, usually. If a child gives evidence in sexual abuse case, a small child prior to age of 10, for example, and describes the acts which were committed against her or him, and he uses his terminology which is age appropriate and says what has done to him or her, and we do not have serious problems believing this statement. We do not usually need additional interviews if the first statement or first interview is well done. An expert in criminal proceedings concerning minors and vulnerable victims is important if the trauma is so severe that they cannot be interviewed again in court. Children under the age of 14 are usually not interviewed again, but since the age of 14 is a criminal responsibility age, which means that you can be criminally held responsible for giving false evidence in court, then the victims who are 14 years old and more are usually heard again, interviewed again in court. We can use different measures to protect them, as I said, with video conference, with judge asking questions presented to the judge by the prosecutor and the defense lawyer. But the child over 14 is usually interrogated in court. And what else I wanted to say? And the punishments are more severe in case of criminal offense against children than they are in rape case against adults. It's somehow historically this way. And what else I would like to say? There was so much discussion, and I'm forgetting all the information. I was wondering, I have questions to my Lithuanian colleagues. Is it mandatory by law to have this psychological assessment in every case the victim is underage? We were discussing about a case of a neighbor breaking the glasses, violence used against children, and sexual violence. These are very different type of, the severeness of the crimes are very different in these cases. Is it mandatory to have this assessment? In any case, there is a child victim. This is my question, back to you.
Atsakydama jūsų klausimą, norėčiau pabrėžti, kad
To answer your question, I would like to highlight that there's no law obliging to carry out complex psychiatric or psychological assessments for minors who are harmed. So it's the prosecutor's decision whether to go to the court and to ask whether about the forensic assessment. And I would like to share our experience about our experience in a courtroom, how defendants ask the court to carry out the assessment to determine the reliability of a minor's testimony. And we have a very good trick for that. We asked to invite a psychologist who helped the court to conduct the interview of a victim. We asked the psychologist about certain verbal and non-verbal cues regarding the child, and a psychologist answers questions about children's behavior, verbal behavior, non-verbal behavior, the words that the child used, whether any signs during the interview that the statement of a child could be influenced by other people. These interviews are accepted by courts, and then we can avoid those assessments in this way. I would like to thank all the participants of the discussion, and I can see that we are running out of time, so we should probably conclude and summarize the results of our conference. And I would like to invite Martyną Dobrovolsky, Vice Minister of Justice, who's going to talk about future insights on this topic in terms of Lithuanian context. Martynas, the floor is yours.
Ačiū Jums labai už suteiktą žodį.
Thank you for the floor, dear organizers, dear presenters, dear guests, participants. It's a great honor for me to participate here in this conference and to hear good practices as well as bad practices. It's very important to hear all of that. It's very important to hear from policymakers. And children-friendly justice from the point of view of our ministry is multifaceted, multidisciplinary, because children-friendly justice is focused on harmed children, on victims, but we have to focus on the suspects as well, who actually are influenced by the criminal procedure. We have the punishment system, and I'm glad that today in Lithuania we have only 12 minors imprisoned, 6 are detained, and the other 6 are in pretrial investigation. And this is the smallest number throughout our whole history. All of this is very difficult, and I'm glad that today we have defined at least one part of the whole picture, because the topic is very broad. I would like to give regards from the Minister of Justice for gathering here, for discussing, for sharing your expert knowledge, for sharing your experiences. Our minister heavily focuses on children, especially children who are victims of crimes. And this government and our minister, we have ambitious goals related to the implementation of European legal acts, and listening to the proposals of our stakeholders regarding our legislative initiatives that would help to protect children even better and to create a children-friendly justice. The process is ongoing, and we're basically at the very beginning of it, and there's so much we can do here. In terms of legislation, I have experience in this area for a 6-year experience, and as a Vice Minister of Justice, I'm in a very bad position because we need to align the interests of a child, also the interest of the defense lawyer, non-governmental organizations, courts, and other partners. And the positions regarding these questions are vastly different. Certain stakeholders evaluate certain measures as disproportionate, while others evaluate the same measures as normal. And we need to react and to try to strike a balance between different interests of different stakeholders. And I would like to highlight that we don't think that the legal regulation that would prohibit additional interviewing of a child, because there were proposals to ban the defense from questioning a child's statement. So I don't think it's a good way. We have the same goal. We want to protect the interests of minors, but as our participants and prosecutors said, in the Lithuanian framework, we can sometimes we tend to do more to avoid certain risks in terms of evidence. And no prosecutor, no officer of pretrial investigation or a court will be looking for objective data, assessments. Talking about this, in this context, I would like to thank the psychiatrists and psychologists of the court. Your work that's very difficult and poorly paid work is very important in these cases in order to protect the victims. And the ministry is supporting you and will try to allocate more funds and to increase your wages. And we understand that without these experts, without these professionals, it's impossible to achieve a child-friendly justice. Perspectives for future. There's quite a lot of them. In the near future, we have probably reached the agreement between the European Parliament and the member states regarding amendments of two directives. First of all, the directive on the fight of sexual exploitation of children, and another one. And these directives could strengthen the protection of minors in the context of obligatory multidisciplinary cooperation. And we understand that since step one, all of the institutions need to be involved in the process, not only the prosecutor's office, but also psychologists and other experts. And this process will be obligatory, and we will have to draft plans for coordination and to have institutions that are responsible for these different institutions working together in the process of trying to support children. And these directives will achieve this goal, because the process of protection should not end with conviction. Those victims need social support in the aftermath. We talk about some medical support. And in Lithuania, all of that falls within the competence of various institutions, various ministries, and our ministry, the police department, the prosecution, all of these institutions struggle to coordinate their actions, but will need to do that in the near future. Is it possible to achieve a completely trauma-free process? I have doubt, because the criminal procedure often affects minors heavily, and we as legislators, policymakers, have to try to minimize the damage as much as possible. And we discuss with the police officers that only in exceptional cases we need to do certain things. And we need to improve the methods we are applying. The ministry has a good measure, well, at least in our view, it's a good measure. But we are promoting a state-supported legal help to specialize in minors' law. Is it working? I don't know, you can tell me that, because we had a situation where we have a state-supported lawyer and they basically coach the victims how to testify. But the question is very sensitive and we need the involvement of all experts. We have collections of documents, and we are above the EU average. And I'm talking about certain things that Lithuania did and achieved 10 years ago. But the collections without competent experts who are well versed in minors' law, they're worthless, because very often the problem is not the framework, but the implementation of the legal framework, the lack of coordination, different interpretations. We had the question of court psychologists. In the Ministry of Justice, we administered the list of those psychologists, the psychologists that had to be invited as people who could help in interviews with minors. Although it turned out that we did not have any requirements, any competence requirements for them. And there was a pretrial investigation. We needed an interview. We invited a psychologist. A psychologist was late for 4 hours. Everyone was listening to them, waiting for them. He talked to a child and he said that I'm not going to ask those questions for child because it could be traumatizing questions for that child. And the police officers were in shock. This understanding of a forensic psychologist and his understanding of the procedure was appalling. So we have the framework, but the practical implementation is not ideal. I could continue talking and talking, but we don't have enough time. So this is a very ambitious topic. I hate this topic as an expert because this is a very negative topic. It's not a positive topic. But I would like to thank once again everyone for the opportunity to listen to your best practices. This is very important for policy makers, for those people who can hear certain things and who can come up with certain legal acts and turn them into reality, and to cooperate with all partners to coordinate our actions, which takes a lot of time, and sometimes processes are delayed and don't happen as quickly as possible. So thank you, organizers.
Dėkoju, gerbiamas Martin.
I thank Mr. Vice Minister, and now the advisor to the Minister of Health wanted to say a few questions. Well, I wanted to make a proposal to finish our conference. Well, I have a small remark. You spoke about psychologists from the list. These were not forensic psychologists. I think that it is not worth discussing that. But when I start listening to you, Martynas, I thought that you would speak about money. And thankfully, I have not heard anything about the money. Well, I represent the Ministry of Health. We had representatives from other ministries, and forensic assessments are the responsibility of the Ministry of Health. So what we often hear is that we need more money, we need more money. And in those 2 days, we have not heard such a remark. And I thank very much. We, I believe, have moved to a completely new level, thanks also to our foreign guests and experts who shared their experience. Another important thing is that I've heard your willingness to mobilize us for our cooperation. Well, I've made my promise. I believe that our other partners also made their own promises that we will continue working together. Thank you very much. Well, the conference is actually moving towards its end. I thank the guests for coming here, for showing their willingness to join us. Unfortunately, the majority of our guests, hopefully they're on their flights home. I thank all of you who've joined us here physically and also online. I believe that the main goal of this conference was to find the breakthrough in changing something, in learning from each other, and preventing ourselves from criticizing. Do not think that we are criticizing you. We were just looking for solutions in order to improve the situation and to ensure that the children's lives are better. We need to actually alleviate this burden from our shoulders and improve the environment for children. I thank you for cooperation and for today's and yesterday's conference, and goodbye.